May I, Your Lordship?
Yes. Noted that none appears in call for the petitioner. As per order dated 1/5/2023, the matter was ordered to be listed after 6 weeks, awaiting outcome of a batch of writ petitions with WBC 6628 of 2018 as a lead case. Thereafter, the petitioner has remained absent on 21/2/2024, 3/10/2024, and 4/10/2024. So with the next para, for ends of justice, the matter stands adjourned today. If the default continues, on the next date of listing, my adverse orders will follow. Madam, just you have completed here. You have completed here. No. Wanted this. This status key agent, so principal seat. Okay. So for the next one, we'll pass orders in. Yes, we are just checking up the status of this first item 1. You are there for the government,
Yes, Your Lordship.
Just record represent. Ipango, government.
Maybe. My lord, my instructions are that the recruitment rules have now been approved by the department and is yet to be notified, my lord. So my lord, let it come after 4 weeks, my lord. In the meantime, we are hoping that it will be notified. So coming to report only one is published in the Gazette.
Okay. What rules?
My lord, please.
Assistant
Just a moment.
Assistant Director Small Saving
Yes, yes.
Recruitment Rules.
Yes,
A new rule has been brought in.
yes. My lord, this is a peculiar case. 2019, when the matter was being argued, on behalf of the government, it was submitted that they are in the process of, my lord, amending the rules. 2019, my lord, they are still doing it. No, but I'm told, my lord, that government has now approved the department also and has to be, my lord, published in the Gazette.
Okay. So, the Pangal and counsel for the petitioner has submitted that as per instructions received by him, the state government is in the process of notifying the amended Assistant Director Small Saving Recruitment Rules of 1999. Yes.
I'm for private respondent.
Okay. Mr. C. Modi is present for the private respondents.
I'm for the state, Your Lordship. 1, 2, 3, and 4.
Speak on and government advocates, applications for respondent 5. What do you say about this amendment? You have instructions?
See, only we are saying that, Your Lordship, the proposal was written.
Just pass it on. If it is pending since 22, then we take it up. And here the matter, the government is perhaps waiting for an earthquake to have the pen moved. Man is in place, pen is in place. Only an earthquake to move that pen, right? Next, as per the instructions available with the learned government advocate, it dated, the instructions dated 14/6/2022, available with the learned government advocate, comma, the department of the concerned department under the Directorate of Small Savings, Naharlagun, sorry, Government of Arunachal Pradesh, has stated that the departmental proposal for modification of the recruitment rules in respect of the deputy director, assistant director, and field publicity officer has been vetted by the AR, means
Administrative reforms.
Department of Administrative Reforms, Law Department, Finance Department, as well as Arunachal Pradesh Public Service Commission. And the matter is now submitted for approval of the Chief Secretary, Deputy Chief Minister, and Chief Minister, and thereafter approval of the Cabinet. And thereafter final recruitment rules would be published in the Gazette notification. So, almost 3 years has gone by. So accordingly, as the matter is pending for the Chief Secretary, we direct the Chief Secretary to send instructions to the government advocate as to whether the proposal is still pending or discarded by the State Cabinet. Next, if such instructions are not received, as this writ petition is of the year 2017, the court proposes to hear the matter on merit on the next date of listing. Next, the learned government advocate shall send a downloaded copy of this order to the Chief Secretary, Government of Arunachal Pradesh, to bring this order to the notice of the said authority.
Obliged.
You take back your instructions. We'll give it instructions. Please take back.
Item number 3 and 4.
वापस कर दीजिए. Just one minute.
There is no need for it, so they cannot.
Yes.
My lords, good morning, my lords.
Yes.
My lords, I'm for respondent number 6, my lord, in both the writ appeals.
Yes.
My lord, for the convenience of argument, I may be permitted to refer to writ appeal number 10,
Okay.
my lord.
Writ appeal
My
10.
lord,
Yes.
my lord. My lord, my lord, I'm being owned and controlled by the central government. I'm a public sector undertaking, my lord. I am engaged in the business of establishing transmission systems, my lord, creating transmission systems and maintaining transmission systems.
Yes.
May I, my lords? My
Yes,
lords,
please proceed. Please proceed.
my lords. My lords, one of the main grievance with which the writ petitioners have come and preferred this appeal, my lord, is that the judgment has gone beyond and the judgment has not addressed the issues which they had raised in their writ petition, and thus it is brought them to this honorable court, my lords. My lords, if we can travel down, my lords, to page number 23. Ma- uh, my lords, we can travel down to the prayer in their writ appeal. The writ petition, my lord, which was annexed. The internal page of the writ petition would be page number 23, my lords. And the outer page would be, my lords, page 105.
Your page numbers are not matching.
My lords, the writ appeal 10, which I'm holding, page number 106, my lord, is the prayer.
Yes.
My lord. My lord, the prayer starts from page number 105. If I may, my lord.
Please continue. Please continue with.
My lord. My lord. My lord, we can straight away come to prayer number 2. A writ of mandamus shall not be issued in directing the respondent authorities to pay the land compensation as per the provisions of the laws, including 1. Right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. 2. Electricity Act 2003. C. Indian Telegraph Act 1885. My lord, these prayers in itself were contrary to each other, my lords, and they cannot be fitted into a single jar collectively. Now, my lords, to understand this, my lords, if we can have the right to fair compensation and transparency in acquisition, rehabilitation, and resettlement act 2013, my lord, and go to section 105. My lord, section 105.
Yes, please proceed.
My lord, provisions of this act not to apply in certain cases or to apply with certain modifications. 1. Subject to subsection 3, the provisions of this act shall not apply to the enactments relating to land acquisition specified in fourth schedule. My lord, now if we can go down to the fourth schedule. My lord, entry number 12. My lord, it says at entry 12, the Electricity Act 2003, thereby clearly specifying that the Land Acquisition Act is not applicable upon us. My lord, that brings us to the reason as to why. And my lord, that answer we find it in section 164 of the Indian Electricity Act, my lords. Which bestows the powers of the Telegraph Authority upon us, my lord. Now, my lord, specifically part 3 of the powers that have been given to the Telegraph Authority, my lords.
Which provision?
My lord, section 164 of the Indian Electricity Act, my lord. My lord, may I continue?
Yes, please continue. Don't stop.
My lord. My lord, we have been given the powers of we have been bestowed with the powers as have been contained in the Indian Telegraph Act Part 3, exercisable by a Telegraph Authority. We shall exercise the same. My lord, Part 3 of the Telegraph Act, in specific section 10, my lord, is of essence to us over here. My lord, if we can specifically, my lord, travel down to subsection B of section 10, section of the Telegraph Act, my lord, Part 3.
Yes.
My lord, it says the central government shall not acquire any right other than that of a user only in the property over, along, across, in or upon which the Telegraph Authority places any telegraph line or post. Now, my lord, what I'm trying to place before my lords here is that the reason why the Land Acquisition Act, the 2013 Right to Fair Compensation and Rehabilitation Act, or any act of that akin is not applicable to us, and we have been exempted, is because, my lord, we do not acquire any land. We do not acquire the right over any land other than that of a user. Now, my lord, until 2015, my lord, this is important to understand the present context, my lord, with which we are dealing. Until 2015, my lord, we were only paying compensation in the nature of surface damage and or tree crop compensation, my lord. That would mean, my lord, if any damage was done to the land while we were erecting either the towers or we were stringing the towers, that is, we were creating a transmission system by stringing, my lords. If any damage had happened to the land, we would pay compensation for what was the actual damage, my lord. And two, my lord, if there were any trees or crops on the lands and they were damaged, we would pay for whatever was the cost for them as determined by the appropriate state authority. Now, my lord, in 2015, my learned brother here representing the state, my lord, I will request him to place the notification. My lord, in 2015, the central government constituted a committee under the aegis, my lord, that the compensation which we were giving under section 10B and 10B, my lord, was inadequate. So the central government came up, my lord, they constituted a committee, my lord, and on 15th of October 2015, my lord, they issued certain guidelines. Now, my lord, what is of essence here, my lord, is para 2, my lord, 2.1 and 2.2. Now, my lord, these guidelines before I proceed ahead, my lords, these guidelines were in the form of recommendations only. These guidelines were not binding in 2015. My lords, I'm audible. My lords. My lords, I'm audible.
Yes, please continue.
My lord. My lord, these recommendations would only attain finality when each state government adopts them. Now, my lord, in these recommendations at para 2, 1 and 2 are again of concern to us, my lord. The recommendations made by the committee are hereby formulated in the form of following guidelines for determining the compensation towards damages as stipulated in section 67 and 68 of the Electricity Act 2003, read with section 10 and 16 of the Indian Telegraph Act 1885, which will be in addition to the compensation towards normal crop and tree damages. This amount will be payable only for transmission lines supported by a tower base of 66 kV and above, and not for sub-transmissions and distribution lines below 66 kV. 1. Compensation at the rate 85% of land value as determined by the district magistrate or any other authority based on the circle rate, guideline value, stamp act rates, or tower base area between four legs impacted severely due to installation of tower pylon structure. 2. Compensation towards diminution of land value in the width of right-of-way corridor due to laying of transmission line and imposing certain restrictions would be decided by the state as per categorization type of land in different places of state, subject to a maximum of 15% of land value as determined based on circle rate, guideline value, stamp rates. Now, my lord, why was the district magistrate or the state authority interested, my lord, to determine the rate? Because, my lord, determination of circle rate is a subject which the state possesses, my lord. Now, my lord, page number 114, my lord, of the writ appeal. My lord, as already pleaded by me, these guidelines of 2015 were only recommendatory in nature. They were only recommendations. And once the state adopts them, they come into being, my lord. Now, my lord, page 114 is the notification dated 29th August 2019, my lord. My lord, this notification reads, the governor of Arunachal Pradesh is pleased to adopt and notify the following rates of payment of compensation towards damages in regard of right-of-way for the transmission lines in accordance with the guidelines of the Ministry of Power, Government of India. Wide reference number so-and-so, transmission dated 15/10/2015. My lord, the notification we have, which I have placed before you, my lords. For maintaining uniformity and compensation, payment to the affected landowners. My lord, this phrase is of paramount importance to decide the matter, my lord, at hand. Affected landowners during construction of transmission lines. It has been decided that a similar payment methodology towards compensation shall also be adopted in the state of Arunachal Pradesh. These guidelines of payment methodology of compensation towards damages as stipulated in section 67 and 68 of the Electricity Act 2003, read with section 10 and 16 of the Indian Telegraph Act 1885, shall be in addition to the compensation towards normal crop and tree damages. This amount will be payable only for transmission lines supported by tower base of 66 kV and above, not for sub-transmission and distribution lines below 66 kV. 1. Compensation at the rate 85% of land value as determined by the district magistrate or any other competent authority based on government approved rates, circle rate, guideline value, and so and so. 2. Compensation towards diminution of land value in the width of right-of-way corridor due to laying of transmission line and imposing certain restrictions at a maximum rate of 15% of the land value as determined by the Deputy Commissioner or any other competent authority based on the circle rate, guideline value, stamp rate acts. Now, my lord, the two figures, that is 85% and 15%, my lords, these may be recorded to understand the next guide notification which they have challenged as being impugned, my lord. Now, my lord, this notification, it reads that it is in respect of the landowners. Persons who have clear title over the land, they will be given compensation at the rate of 85% for the tower base area and 15% for the right of corridor, my lords, which is in addition to the surface damage and tree crop compensation as was being paid until the coming of this notification, my lord. Now, my lord, page number 111, my lord, is the impugned notification that they have put for my lords. My lords, the notification of 2019 was the adoption of the recommendations given in 2015 in respect of the landowners. Now, my lord, a special peculiarity cropped up in the state of Arunachal Pradesh where they had forest dwellers. A sizable section of the population who were dependent upon the forest areas. So, my lord, what the government of Arunachal Pradesh did, they came up in 31st of August 2023 and issued a notification which is impugned here, my lord. It says, my lord, the language of this notification, in the interest of public service, the governor of Arunachal Pradesh is pleased to notify the special ex gratia relief package towards right of way for 132 kV transmission lines passing through reserve forest under the comprehensive scheme for strengthening of transmission and distribution system in Arunachal Pradesh policy. For the purpose of facilitating completion of the statewide project for economic development of the state of Arunachal Pradesh as under 1. Subtitle and commencement. The policy may be called the Special Ex Gratia Relief Package towards right of way for 132 kV transmission lines passing through the reserve forest under the comprehensive scheme for strengthening of transmission and distribution system in Arunachal Pradesh 2023. It shall come into force on the date of its issue and remain effective until further orders. My lord, para number 2 is where it sums up. A, for the tribal population as identified in para 3 of this policy, my lord, who are not entitled for any benefits, including compensation of specific nature, resettlement or rehabilitation benefits, and ex gratia package amount equivalent to half of the rates of the notification dated 2nd of September 2019 would be payable, which will be, my lord, 42.5% for the tower base area, which is 50% what was being paid to the actual landowners, that is 85%, my lord, and 7.5% for the right of way, which is again 50% of the maximum 15% which was being paid to the affected landowners, my lord. This is for people who are not entitled to any benefit. As a social welfare measure, my lord, the state has come up with the notification. Now, my lord, they say that the individuals will be identified by a board which will be constituted by the Deputy Commissioner of the concerned district, my lord, which will be a board akin to the board constituted in the matters related to land acquisition. The constitution of the board, my lord, they are saying should be done how it is being done in the land acquisition. But they are not saying that this board will acquire the land, my lord, because we don't acquire a land. So, the authority who will identify the land, my lord, is an authority. The notification says the Deputy Commissioner will constitute a board to identify these people who have claims. Now, my lord, the impugned judgment, my lord, At page 72, the court says, my lord, para 32, 33, 34, and 35, my lord. At para 32, page 72, if I have my lords at page 72, my lord. My lord. Para 32. From the reading of the above notification, it is seen that the rates of compensation calculated as stipulated under section 67 and 68 of the Electricity Act 2003, read with section 10 and 16 of the Indian Telegraph Act 1885, can be given to only the affected landowners. Thus, it can be understood that the impugned notification dated 31/8/2023 has addressed those tribal population within the reserve forest area who are considered not entitled to any benefits for not being the landowners, but who have certain rights under Section 3 of the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. My lord, para 3 has been reproduced. The forest rights at para 33 of forest dwellers, scheduled tribes, and other traditional forest dwellers on all forest lands under section 3 of the act includes right to hold and live in the forest land under the individual or common occupation, for habitation or for self-cultivation or livelihood by a member or members of a forest dwelling scheduled tribe or other traditional forest dwellers. 2. Community rights, rights of ownership, access to collect, use, and dispose of minor forest produce, which has been traditionally collected within or outside the village boundaries. 3. Other community rights of users or entitlements such as fish and other products of water bodies, grazing, etc. Thus, if these rights have been affected by the transmission lines passing through the reserve forest, even if they are not entitled under the notification dated 2/9/2019 para 2A, of the impugned the para 2A of the impugned notification has taken care of them, wherein they are said to be entitled to half the rates of the guidelines of payment methodology of compensation towards damages as stipulated in section 67-68 of the Electricity Act 2003, read with section 10 and 16 of the Indian Telegraph Act 1885. So they may not be the landowners. Thereafter, para 3 of the impugned notification refers to the identification of such persons entitled under para 2A of the impugned notification dated 31/8/2023. My lord, para 34 and 35 is important. Thus, this court finds that the notification dated 31/8/2023 issued by the government of Arunachal Pradesh could be appropriately termed as a gesture of goodwill to pay special ex gratia relief package towards right of way for 132 kV transmission lines passing through reserve forest, wherein the payment has been computed at the rate of 42.5% of the land value towards tower base area and 7.5% of the land value towards diminution value of the land in the width of the right of way corridor due to laying of transmission lines, which would be determined by the deputy commissioner or any other authority so empowered by the state government based on district rate, circle rate, etc., to those persons not entitled under the Electricity Act 2003 and the Indian Telegraph Act 1885, but have certain rights under the Scheduled Tribes and other traditional forest dwellers, Recognition of Forest Rights Act 2006 within the reserve forest area. From the above reason, this court finds that there are no grounds for setting aside the impugned order, that is the notification dated 31/8/2023. This court also finds that the petitioners in the instant writ petition have not established that they have the valid LPCs within the reserve forest area, which is made clear from the nature of their prayer in the writ petition, wherein the prayer is to take cognizance of LPC applications pending with the state administration, and therefore their claims for consideration of any compensation cannot be considered at this stage. The court, however, observes that in the interest of justice, the concerned respondent authorities should dispose of any such pending applications expeditiously. Now, my lord, to sum up, my lord, the 2019 notification is for the landowners. The state, as a social welfare measure, seeing the forest dwellers, and as have been defined under Section 3 of the 2006 Forest Dwellers Act, my lord, they publish another notification which they are saying impugned to give some compensation to those people whose livelihood is being affected to that forest area from where the line might go, fixing a rate. Now, they have a problem with this notification. They are saying that they should be given 100%. For that, they have to be landowners. Now, my lord, what we see from para 33, where section 3 of the Forest Dwellers Act has been reproduced, my lord, my common understanding, my lord, when I read that, I understand that these are those people who are continuously staying in the forest area and they are dependent on their livelihood and survival from the forest produce. Now, my lord, let us see the cost title of their writ appeal, my lord.
That submission was already made yesterday. Don't have
My
to
lord,
repeat it.
my lord,
Yesterday, that submission was made by the learned AG. Learned
my
AG
lord,
had made that submissions. Not repeat it again.
my lord, if I have not missed, my lord, in one line, I will only submit that their address shows that they are not residing in the forest.
Take
My
a
lord,
note of that.
my lord. So, my lord, what brings me to the culmination part is that, my lord, they had come up with twofold prayers, my lord, wherein firstly they had said that to quash the 2023 notification where a special ex gratia package is being given. For reasons best known to them, the court has turned down the said prayer, my lord. Their second prayer was to give them compensation under the Right to Fair Compensation and Resettlement Act of 2013. The act itself bars the authorities from putting us under the ambit of that act. Now, my lord, the court has also made an observation that they do not hold valid LPCs. Neither have they been able to make out a case, my lord, where they are actually the people who deserve this compensation. Now, if these disputes exist, my lord, law still does not bar them. Section 16 of the Telegraph Act, my lord. To be specific, my lord, section 16(4), 16(3), 4, and 5, my lord. And in their case, my lord, section 16(4) befits. It says, if any dispute arises as to the persons entitled to receive compensation or as to the proportions in which the persons interested are entitled to share in it, the Telegraph Authority may place into the court of the district judge such amount as it deems sufficient, or where all the disputing parties have in writing admitted the amount tendered to be sufficient, or the amount has been determined under subsection 3, that amount the district judge, after giving notice to the parties and hearing such of them as desires to be heard, shall determine the persons entitled to receive the compensation, or as the case may be, the proportions in which the persons interested are entitled to share in it. So, my lord, the law says if they are having any entitlement, my lord, they will have to prove their title. And in their case, my lord, if they are not the owners, but they say, my lord, that they are the forest dwellers, then, my lord, they will have to go and appear before the board, which has been constituted under section 3 of the notification, to go and show that, yes, we are the ones who are entitled to receive compensation under the 2023 special ex gratia package. Else, they will have to show that they are the landowners, my lord, to receive compensation under the 2019 notification, which is in addition to the already existing surface damage tree crop compensation which would be given. So, my lord, they have got no case to be made out here. As regards the, my lord, IA is concerned, where they have challenged a new notification, my lord. They have not challenged this notification in their writ, my lord, in the writ petition. They never challenged this notification in the writ appeal, but they have come in the IA with a prayer to stay it at page 52, my lord. My lord,
The IA.
52 of the IA, my lord. They've jumbled up, my lord. This was never challenged in the writ. My lord, this petition, this particular notification has not been put to challenge in the appeal. But they have asked for a stay of this notification. My lord, it is my duty to bring to my lord's notice. What is this order, my lord? My lord, para 3 sums it up. It says, therefore, a board is hereby constituted with the following officers and members for carrying out ground survey and assessment of land and properties, and also identify the genuine landowners of the affected area. Now, my lord, this is in compliance and in continuity to the 2019 guidelines, which are an adaptation of the recommendations made in 2015 by the Union government. Because it is for landowners, my lord. They had put to challenge the 2023 notification, my lord, which was a special ex gratia package. For that is something which the state has gone one step ahead and has traveled in its boat of social welfare for social welfare measures, my lord, as have been rightly observed by the learned single judge, my lord. So this notification has got nothing to do with their case, my lord. Now they will have to decide whether the 2023 judgment is wrong in law, and then they are saying, no, we are also the affected forest dwellers. Please recognize us.
The same notification which they have tried to put to challenge. My lord. So, my lord, at best they have got no case here, my lord. Without proving that they are the ones who will benefit out of a particular notification or not, they are trying to put to challenge that particular notification which has been published for the social welfare of the state at large, my lord. My lord.
Is best, my lord, as it exists, as it stands. From the point of facts and from the point of the operative law on which it is being dealt with, my lord. My lord, I am humbled, my lord, by the patient hearing and the time given to me, my lord. I rest my submissions on it. Highly obliged.
Lordship, I hope I will not be taking much time. I will very shortly make a statement that much confusion seems to be coming from assigning to us the title of merely being forest dwellers. We are forest dwellers with land rights, and the whole fulcrum on which the judicial question will turn, the judicial answer will have to be obtained is, are we having land rights? Or are we not having land rights? Everything else, your lordship is and your ladyship is peripheral to that question. And that central question, your lordship, has been completely missed by the honorable single judge's order. And I'll take you to the same paragraphs which my learned friend just now took you to and reinterpret them to assist the court. Your lordship, page 69, para 27. Page 69, and I'm talking of Writ Appeal 10. Writ Appeal 10, page 69. This is from the judgment. Your lordship, the honorable judge concludes in third para, thus it is seen that a person cannot claim for land compensation on the construction of 132 kV transmission line or for right of way with the within the unclassified forest area or within reserved forest area as per the provisions of law, but can only claim compensation for surface damage or trees or crops. Your lordship, this is the conclusion which is incorrect. If you lordship sees the very pleadings that my learned predecessor just made, there are two compensations. One pre-2015 or as adopted in 2019 by the state government, which is a uniform computational method for duration of land. And the second compensation is regarding surface damage. Further, your lordship, in this para, kindly note, person cannot claim land compensation. Your lordship, land compensation is not being claimed by anybody. This is a confusion between, I'm sorry, what I was trying to say, your lordship, is the land compensation here is sometimes in another places. The land compensation is what is being claimed, your lordship, but not for acquisition of land, only for duration of land and damages. So there are two compensations which are being claimed, whether it is reserved forest area or unclassified forest area. One, surface damage, and two, under the 2015 provisions adopted by the state in 2019, a formula of 85% and 15% for duration of land. Now, your lordship, coming to para 28, it very clearly says, and correctly so, that in unclassified forest area, all people have been identified and compensated. My learned friend representing the state also said that we accept it. Why is this? This is important. Because right in the beginning, I showed your lordship that all notifications were for USF area only. And right in the beginning, it was declared that in reserved forest, there was no need to conduct the exercise. Coming to para 31, your lordship. Page 71. Now, your lordship, the last 3 lines before the quotation, this is talking of compensation as per Electricity Act and Telegraph Act. Notifications were also according to the invitation for claims and objections were also based on only rights. The rights under the FRA 2006 Act were not considered, your lordship. Now,
Right,
your lordship, coming to para 32 on the next page.
right under this
Lordship.
scheduled tribe, other tribes and forest dwellers.
Yes, that is the FRA Act 2006, your lordship. That's commonly known as 2006. Your lordship, coming to para 32. This was quoted by my learned friend just now. And I agree with what he quoted, but I must point out, your lordship, Section 3 of the Scheduled Tribes Other Act, which has been taken care of, has been referred to here and again referred to in the next para. Your lordship, I am afraid that the learned judge has missed what Section 3 says. The learned judge has quoted some provisions regarding rights of forest produce, rights in the forest, taking minor produce. But what has been missed, your lordship, is I had pointed out yesterday, your lordship, Section 3(4). Section 3(4). Section 3(4), your lordship. May I read, your lordship?
Yes.
Yes. Section 3(4). A right conferred under subsection shall be inheritable but not alienable, transferred and shall be registered jointly in name of both spouse in case of marriage. Then, your lordship, come to 6. Para 6. Under Section 3. These are not rights which are just community rights. These are property rights, where the forest rights recognized and vested by subsection are respect of land mentioned in clause A of 1 and 2 shall be under the occupation of individual, family or community on the date of commencement of this act, and shall be restricted to the area under actual occupation, and shall in no case be an area more than 4 hectares. Your lordship, this is crystallized right, land right. It is not a community right. The rights which the learned judge is considering under this section are community rights. So I humbly want to point out that there are specific land rights which the judgment ignores. And my entire case, your lordship, is if we are not landowners, there are 109 in one writ petition and about 5 in the other. We deserve nothing under the provisions of law. We deserve something as landowners. And thereby, it is very important that we be given the opportunity to prove our occupation of the land. Again, Your Lordship, in para 34, 73, page 73. The learned judge holds that in the last line, to those persons not entitled under the Electricity Act, Forest Act within the reserved forest area, because they are not landholders. Our entire cases, we are landholders. We are not being given the opportunity to prove that. Now, Your Lordship, you had yesterday raised the issue of the forest. I'm sorry I couldn't help Your Lordship yesterday, but I was the advocate in the petition 20 also. And fortunately, at that time also this question came up, and I gave a specific comprehensive description regarding the forest, which I can show Your Lordship right now to assist you in making an assessment. This is page right, Lordship, page 199. I start from page 193, Your Lordship, 194 it is. 193 I start, Your Lordship. Page 193. This, Your Lordship, are the pleadings of, not pleading, judgment of writ petition 20 of 2009. And this is on same area exactly where this is happening. The area is the same. Your Lordship, para 11. Now this describes, Your Lordship, the genesis of the reserved forest. So, Your Lordship, if you turn the page, Lordship may turn the page to 194. This gives the table. Your Lordship may remember I pointed out this is called Papam Forest, reserved forest. This gives the boundaries, it gives the area, and Your Lordship, Lordship, if you turn to page 195, it further talks about the evolution of this forest area. Para 12, Your Lordship. May I read, Your Lordship?
Not required, easily.
Para 12, page 195.
Yes.
In fact, one of the several parties here are common, Your Lordship, to the parties before you. Now, the said notified area previously came under the territorial jurisdiction of DFO Khelong Forest Division. Bhalu Pond, please excuse me the pronunciation, Your Lordship. And the land in question in respect of which the LPCs have been issued to respondent 7 come under Sejosa Forest Range. Many of the persons before Your Lordship in this writ appeals are also from Sejosa, which was bifurcated into 2 independent forest ranges, namely Sejosa Range and Namura Range. I showed this yesterday also when I discussed. Governor Order Number 20, the advisor of Governor Shillong. The official respondents, including the respondent concerned, have not denied the issuance of forest. This is, but I just wanted to satisfy Your Lordship regarding the reserved forest area. Yes, Your Lordship. Your Lordship, the other issue I want to address is my learned friends have been questioning the factum of LPCs issued under FRA 2006, post 2007 when it was implemented. Your Lordship, the 2 LPCs we have attached are post and are under that act. One is of 2010, the one is of 2014. In other cases, Your Lordship, what has happened is that applications have been made And I'm telling you, after consulting the clients, applications have been made. And those applications, your lordship, when I was surprised, are treated as effective LPCs, though actual LPCs have not been issued. I have attached all those applications. In fact, your lordship would be, I'm just discussing aside. My client was saying, why have you added them as applications? They are all LPCs. We are using them for whatever purpose that. And in fact, what my client told me is that Power Grid has given compensation based on similar applications, treating them as evidence of their possession. Now, lordship, the important thing, your lordship, is central government has a developmental scheme for creating infrastructure. Central government is funding it. That scheme in this particular case involves setting up a high tension cable, transmission line. Your lordship, it goes through two kinds of areas in the state. Arunachal, your lordship, is a number one, sparsely populated area. Number two, it has the largest forest area in the country. And this transmission line goes through USF.
Percentage wise is Mizoram. 85% is
I
declared
really
forest.
meant, your lordship, in terms of area, not in terms of percentage. Percentage, your lordship, Delhi is also very high.
No, Mizoram is the highest.
No, Mizoram is very high, your lordship, but because Delhi is a small area and the trees are growing there, so the percentage has become very high, which actually 20 years ago nobody expected. So you are right, your lordship. I meant in terms of area, not in terms of percentage. So, but in area, your lordship, one, it is sparsely populated. Two, most of it is forest area and USF and reserved forest. Now, the procedure for following norms for compensation or for inviting bids and objections and identifying population who are, must be the same, your lordship. It can't be different. You can't have one procedure. Do we have two kinds of citizens and two kinds of citizen rights? So all I am saying is the premise on which this notification, the impugned notification of August 2023 is based is that RF, there is nobody who is residing who has land rights. They have ignored the rights under section 3, 4 and 6 of the FRA Act 2006, which I just showed your lordship. Once you take them into account, your lordship, we have land rights. We need to be given opportunity to identify our land rights. That is sum and substance. Now, your lordship, why this order of Honorable Single Judge is in error is because it has ignored this very important factor. Number two, your lordship, we come to the IA. Why the IA is not incorporated in the main writ appeal is because we did not have that document and were not aware of it. And the moment we came aware, we have come before the court on the in IA on that. The other thing, your lordship, about that IA is that IA in law is defective and unlawful for two reasons, your lordship. One is established law, your lordship, that administration cannot approbate and reprobate. Administration has to follow one line of decision making which they are pursuing. Here, what is happening is, in case of USF, administration is following one line. In case of RF, they are following a different line. But till the stage we were facing honorable court in our writ petition, their line was different. It was that people without any rights. Now, in this notification, your lordship, they are talking of affected persons who are landowners. We are affected persons who are landowners. But this notification has not been preceded by a notification for invitation for claims and objections. As was done in the previous case, I took your lordship to that notification. Your lordship, my learned friend representing the state made a very interesting observation yesterday. He said, why don't they participate in the process of this notification of January 25? And they may be given some time to do that. Am I correct? You made this observation?
I say.
That's what I heard.
No, I said, when you came to know about this notification, why didn't you participate? Why did?
No,
you
but
come and
after
challenge?
that, you also said they may be allowed some
No,
time to
that
participate.
was your.
No, I
prayer.
didn't speak after that.
No,
I'm speaking.
your
now.
prayer, I was.
Okay, you are
He's
making,
submitting your
anyway,
prayer.
my prayer, your lordship, is a little more sophisticated than that. My prayer is this honorable court has immense powers to mold release in interest of justice, in interest of saving court's time, in interest of giving a judgment which does not, how should I say it, your lordship, which also feels just to the people. So it's not just a court of law, your lordship. Your lordships always have an eye on justice also, though it may be just a court of law. So what I propose, your lordship, is as follows. There are errors on the face of the record in the judgment. And one of them I showed you regarding compensation being only for surface damage. That's not correct. It has ignored the land rights invested in the people under the FRA 2006 Act. And surprisingly to us, the state comes up with a notification, which is in the IA, that we want to identify now people who have ownership of land. Lordship, what may be done is, we may be allowed to submit our claims and objections given a certain period of time, and then this notification may be allowed to take hold. That's all that is needed to comply with. Frankly, your lordship, I have very rarely seen such a case. At least on paper, everybody's desires would be met. I mean, so that really, your lordship, is the central. Thank you, your lordship, for the patient hearing.
This record.
My lord, I have only one submission to make if permitted.
All good things must come to an end.
My lord, I think it is essential, my lord, since I'm representing an organization, just one submission, my lord. If I may, my lord.
Yes,
My lord,
yes.
the appellant herein has made a statement that based on certain LPC power grid has paid over certain compensatory amounts to other individuals. My lord, this is absolutely incorrect, non-factual, and wrong. As my lord, I have read the notifications and I have showed my stand. We do not directly pay compensation to anybody, my lord.
No. The lordship,
It is by a committee.
He is
My
right.
lord, let me
I have
complete.
not said what
Let
he
me
has
complete.
understood. Yeah, but I agree with what you are saying.
My lord, we have not paid to anybody on the basis of these LPCs or the forms which he is claiming. Once the state authorities who constitute a board, they identify the affected people, my lord. They identify they are the ones who set the rate also, my lord. Because these are all in the ambit of the state administration, my lord. To set the circle rate, their horticulture, agriculture department sets the rate for trees. And that is how it is paid. So we have not paid anything, my lord, on the basis of LPC, as has been said. I'm sorry if I understood wrong, but nonetheless, my lord, I've just tried to make my
Lordship,
position.
what I
clean
meant
and correct.
was that these were presented to the state authority as ownership, and the process of computation of my rights, my means similar personally placed people's rights, were based on similar LPC applications, which have been pending for a very long time in some cases.
The all sides are duly represented, including Mr. M. Ratan, Learned Additional Advocate General, assisted by Mr. L. Parme, Learned Counsel for Respondent numbers 1 to 5, 7. Next paragraph. The submission of Mr. N. Kerala and counsel for the respondent number 6, who appears through video conferencing, is concluded. The reply submissions by Mr. A. Kashyap and counsel for the applicant is also concluded. Next paragraph. Accordingly, arguments are concluded. Judgment is out.
Always, madam.
Highly obliged, my lord.
Yes, Mr. Tiwari.
Come to see the change on the lordship.
My lord. You have come to see an old man.
There is a change, part of the change, but it looks good.
Yes, Mr. Vora.
My lord, I would like to mention item 18 and 19. Herein I was supposed to file an affidavit. But my lord, I have received the instruction only day before yesterday. So I-
Item?
18 and 19, my lord. United Brothers and Distilleries.
My lords, I appear for the petitioners.
E- 18 and 19.
18 and 19. I need a week's time, my lord, to file the affidavit, my lord.
Okay, you have informed the other side?
Yes, my lord. My learned friend is there virtually, my lord.
Yes, my lords.
Okay.
My lords, and if time can be granted after my learned friend's affidavit, that we can file an rejoinder.
Okay.
And interim relief in both the petitions, my lord, that has been granted before may be extended to the next date of hearing.
Okay. Your name?
Mohammad Anajwala.
Mohammed. Mr. Mohammed Anagwala, counsel for the petitioner, is present through video conferencing on the prayer made by Mr. N. K. Bogod, standing counsel for the GST. It's called GST or CGST?
CGST.
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 CGST. The matter stands adjourned today to enable him to file affidavit in opposition in the matter. List after 2 weeks on a date to be released by the registry.
Highly obliged, my lord.
Yes.
My lords, interim orders may be extended, please.
Okay, interim order passed earlier stands extended till the next date of listing.
My lord.
May I, your lordship?
Yes.
Grateful.
I'd like to mention item number 26 and 27, your lordship. This matter may be listed after 2 weeks, your lordship.
26, 27.
Yes, your lordship.
List after 3 weeks as prepared and counsel for the petitioner. You have a respondent, Ms. P. Pangur, government advocate. Okay.
May I please, your lordship?
Yes. Yes.
Your lordship, I wish to mention item number 23, your lordship.
Huh?
Item number 23, your lordship.
23.
Yes, your lordship. It's a tender matter, your lordship. Your lordship has already fixed similar matter on 22 of this month, your lordship.
22nd.
Yes,
It says it represented. So it is submitted by an counsel for the petitioner that the similar matters are listed on 22/4/2025. So this matter on 22/4/2025.
hello. And one more item, your lordship. Item number 34, your lordship.
34.
I'm mentioning on behalf of E. Perme, your lordship. Elena Perme, conducting counsel. She is out of station, your lordship. Matter may be listed after 3 weeks, your lordship.
Who is out of station?
Elena Perme, your lordship. She is the conducting counsel.
Okay. You have taken consent of the other
Yes,
side?
your lordship, I have taken consent.
Okay, with consent of the other side. And counsel for the private respondent prays for adjournment. Prayer is allowed. Just after 3 weeks on a date to be fixed by the registry.
One more item, Your Lordship, if permits, Your Lordship. It's in our order column, Your Lordship. Item number 24, Your Lordship. As per last order, Your Lordship, court was granted time to settle the matter, Your Lordship, amicably. Your Lordship, there is no scope for settlement, Your Lordship. In this case, Your Lordship.
Okay. You're for the
Respondent, Your Lordship.
private respondent.
Yes, Your Lordship.
What says the representative? Mr.
E. Menjo, Your Lordship.
E. Menjo, learned counsel for the private respondent submits that this court had granted time to the parties to settle the matter amicably. So it is submitted that there is no scope. That there's no possibility of a out of court settlement between the parties. Accordingly, that the matter will be listed after 3 weeks in the admission column.
Your Lordship, there is, I think, interim order is there. Interim order is there, Your
Interim
Lordship.
order passed earlier stands extended to the next date of the hearing.
Highly pleased.
May I please, my lord, I beg to mention item number 16, my lord.
Item number
16,
16.
yes, my lord. I'm appearing on behalf of DK Diori, my lord. If the matter may be adjourned and be listed after 3 weeks, my lord.
After 3 weeks, what says the representative? Just after 3 weeks has paid for one counsel for the petition. Okay.
My lord.
May I, Your Lordship? Your Lordship, I beg to mention item number 12 and 14. I'm here on behalf of standing counsel, Tabatagum. Your Lordship, the standing counsel is out of session. So sometime maybe
You
given.
have taken consent?
Pardon?
You have taken consent?
Yes, consent from the other party is taken.
Okay. Separate orders, both, item 12 and 14. Both sides are represented. The prayer made by learned standing counsel for the education department for the matter stands adjourned today. Just after 3 weeks.
Your Lordship, there is-
Any interim orders are there?
No,
Let's check it. If there's interim order, extend them.
Your Lordship, there is another item.
Why this 2020 matter, you are taking an adjournment
Uh,
5 years down the line?
I have just given instruction to, like since, standing counsel is out of station.
In this 22, you say that on the next day, is this being a matter of the year 2020, no prayer for adjournment shall be considered on the next date of listing. No adjournment.
Your Lordship, there another item number 20, same prayer.
Item 20.
Item number 20, same prayer.
Same.
Obliged.
May I please, Lordship. Lordship, I beg to mention item number 21 on behalf of conducting counsel, Kamal
21.
Saxena. 21, yes, Lordship. We are praying for adjournment today, Lordship, for 3 weeks, and we have taken consent from the other party, Lordship.
Okay, you are for the petitioner.
Yes, Lordship, we are for the petitioner, Lordship.
Which is a representative of the prayer made by learned counsel for the petitioner.
And Lordship, there is an interim order. It may continue,
Just
Lordship.
after 3 weeks. On a date to be fixed by the registry. The interim order passed today stands extended till the next date of listing.
Interim to continue. Deeply applied.
My lordship, I beg to mention one repetition for listing tomorrow, lordship. Only for lordship, only for withdrawal, lordship.
Withdrawn.
I beg to mention item number 13.
Item
Number 13, 1-3.
1-3.
This agenda matter for 2 weeks.
Okay, you are for the petitioner.
Yes.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. List after 3 weeks. Which page is the impugned order?
May I, Lordship?
Which page is the impugned order?
It is in contempt, Your Lordship.
Which page is the impugned, which page is the order which is not complied with?
It's in page number 23 to 25.
Raising non-compliance of the order dated 10/3/2025 asked in WBC 98 of 2045, the present contempt petition has been filed under Article 215 of the Constitution of India, read with Section 11 and 12 of the Contempt of Courts Act. You write a name, your name?
S. Thomo.
Right, so first. Next. You should notice returnable. The petitioners. You should notice returnable in. Give a date after 5 weeks. Returnable on so and so. So the petitioner shall take steps for service of notice on the respondent by registered post lady. Next paragraph. The pendency of this contempt petition shall not be a bar for the respondent to comply with the order of the court. Next paragraph, list on. Give a date after 5 weeks. $19.5. Yes, item 2.
Well, this matter is related to cancellation of GST registration method. The matter came up before today on 2nd of April. Well, so there is a slight defect in the petition. They have not furnished the synopsis and listed dates on that date. So now we have rectified the defects.
Sure. Okay.
So I feel that a similar order may pass, my lord.
Oh, the GST matter, cancellation or registration?
Yes, sir.
Okay. See, only thing, numbers will change.
And regarding item 6 is also the same, my lord.
Just a moment. Your name?
My name is Zirzotaba. Zirzotaba. So
Please speak loudly, I can hear you.
Zirzotaba.
Also heard. Mr. M. Kato, then DAGI for the respondent number 1, and Mr. M. K. Boro, then standing counsel for the CGST and central excise, representing respondent numbers 2 and 3. In brief, the case of the petitioner is that trade under the trade name of Para 3 Locum, LOKAM, Locum Town, TAONG Enterprise. Its principal place of business at Koloriang, Kuring Kamed district, Arunachal Pradesh. Was severely affected due to health condition. in the later part of 2023. And accordingly, from September 2023, the petitioner did not file her GST returns. Accordingly, subsequently, after issuance of show cause notice, dated 5/4/2024, under reference number page 14. Simply top. Yeah. Registration number so and so. In respect of the petitioner's GST registration number, this is also there in page 14. So was cancelled by the superintendent, GST, Colorian. In fact, it was from number 3. Next one. For restoration of in February 2025, the petitioner resumed her business after recovering from illness. So how, as the GST registration has been cancelled, she could not upload her GST returns. Thereafter, the petitioner submitted a letter to the GST office at Nahalagam. Filed an appeal. Submitted a letter dated 17/2/2025 for revocation of the order of cancellation of GST thereafter. The petitioner has filed an appeal before the appellate authority under section 30 of the CGST Act 2017. I don't know, can't you write anything sequence in property? You file an appeal, what has happened, you don't say. We are finding it very difficult to find out. Similarly, there are two paragraphs eight. What you're trying to say, we can't understand. Can't you give some time after drafting to look into it, what you are drafting and presenting? What has happened to the appeal?
One of the.
Appeal, what has happened, page 20? Huh?
Not file appeal in time. If the limitation is 30 days, they brought it on 7 February
No,
2020.
but you see this, no, reading, I'm trying to understand what is happening. It doesn't say anything. Whether it is filed or not, that also is not said. Filed an application and appeal to the appellate authority. When what is uploaded, not said. Whether it was accepted by your appellate authority, not said. What happened to the appeal, not said.
Your Lordship, it was submitted in the portal, GST portal.
What is the difficulty in writing? Tax matters, we'll have to write appropriately an order. So don't say anything. What happened to that appeal? You don't say anything. We can't dispose it off like that. You don't say after that you jump to something else. No, I'm sorry. You can't dispose it like that. You see, that's correct. It appears from the contents of the petition that the readings do not reflect as to when the
Your Lordship,
appeal. It's okay, we are not dismissing it, but we are giving you time to it. Does not disclose the date on which the
Your Lordship,
appeal was filed.
can we take the liberty to withdraw the petition? And
We'll file it again.
Yes, sir.
Do it. So next paragraph is. You just said then, heard so at the outset, they cannot consider the petitioner submitted that there are certain inherent defects in the pleadings and therefore it pays to allow him to withdraw the petition and to approach again. Prayer is allowed. The instant defense from the two with liberty is paid for.
Much obliged.
Yes, item 6.
Well,
Same
item
thing.
6 are similar matter.
No, but whether they are defects here or not.
He is not a. Well, I thought that I will wait till the matter comes.
Huh?
I thought that I will wait till the matter comes. But matter is same, my lord. So in this case, the appeal was not preferred. Because the delayed and order was.
I am trying to just understand the pleadings are complete. Just look into it and tell us. We take it up after 5 minutes. Go through the pleadings and tell us.
Is that?
Yeah, yes, Lordship.
This is okay.
Yes.
Okay.
Okay.
Propose is in page number 26, Lordship. And cancellation in page number 27.
Okay. Your name?
H. Ape, Habung Ape.
Mr. H. Appeal and counsel for the petitioner. It's in the GST. Name of the firm is at paragraph 2. GST registration number is also here. Show cause notice at page 26.
26.
Reference number is there. GST registration number is also there. Page 27, 1, 2022. by the superintendent GST, Naharlagun, Zone 1, Naharlagun Zone 1, Papumpally District. Then order of cancellation.
Well, it comes on our Itanagar range, my lord.
Right.
It will come on Itanagar range.
It's okay. Now we understood on that day. Who is the jurisdictional authority? Then order of cancellation. Page 27, reference number is there, dated 9/3/2022. Issued by passed by the same authorities. Then from para 4 onwards, that the learned counsel for the petitioner submitted that in view of the period of limitation having been statutory period of limitation having been expired, and the condonable period had also expired, the petitioner has not preferred any appeal and has approached this court for a direction upon the respondent authorities to revoke the order of cancellation. That's why the petitioner is projected that he is ready and willing to pay all the GST dues, fine, penalty, etc., and would upload the pending GST returns. Am I allowed? Next paragraph. It is also submitted into same paragraph 5. This will be saved. This will be saved. Okay, we are allowed. Okay.
May it please your lordship. So this is a matter which was taken up the other day. Your lordship's convenience have prepared a table, my lord, giving the page numbers. Lordship had gone through the other day, but just for lordship's convenience.
You got the documents?
Yes. But there are also in earlier tender process, each firm was awarded 2 work, that also he have not furnished. This firm, petitioner firm was awarded 2 packages in earlier tender process, same Vibrant Village program. That information also he has not furnished.
Yes. My lord, in this commissioner's judgment, which I'd like to rely on, my lord. My lord, 2019, my lord, 14 SCC, page 81. Relevant paragraphs, para 9, 22, and 23. The proposition here, my lord, is that if the information is required in a particular manner, it has to be provided in that manner. But if my lord comes to para 9, the decision of the High Court is predicated on two facts. Firstly, the non-disclosure of the factum of the show cause notice issued to the appellant mounted to violation of the undertaking. Linked to this issue is that clause 23 of the tender provided for an integrity pact assuring transparency and fair dealing, and that the integrity pact has been duly signed and submitted by the appellant. Secondly, division bench doubted the compliance by the appellant of clause 8 with clause 10G of clause 4 of the tender. The controversy pertains to the clause dealing with business continuity and requirement of submitting a valid ISO certificate for the purpose of securing the tender, and the relevant clauses are there. Now, my lord may come to para 22. 22, my lord.
Yes.
It is no doubt true that clause 20 does provide for 4 eventualities as submitted by the learned counsel for respondent number 3. The present case is not one where the submission of the tender, the appellant had been banned, blacklisted, or put on holiday list. The question before us thus would be the effect of an action of blacklisting and holiday listing being initiated. The declaration to be given by the bidder is specified in clause 22, which deals with the first 3 aspects. The format enclosed with the tender document also refers only to these 3 eventualities. It is not a case where no specific format is provided, where possibly it could have been contended that the disclosure has to be in respect of all 4 aspects. The format having been provided, if initiation of blacklisting was to be specified, then that ought to have been included in the format. It cannot be said that the undertaking by the appellant made it bounden duty of the appellant to disclose the aspect of show cause notice for blacklisting. We say so as there is no specific clause with specific format provided for requiring disclosure as per the same. It may be possible to contend that the format is not correctly made, but then that is the problem of framing of the format by respondent number 1. It appears that respondent number 1 also faced with factual situation took a considered view, so and so, my lord. My lord, here, if lordship comes to page 71 of the writ petition, Section 3 at the top, my lord, qualification information, notes on form of qualification information. The information to be filled in by the bidders in the following pages will be used for the purpose of post-qualification as provided for in clause 4 of the instruction to bidders. That is what they are relying on, my lord, is clause 4, my lord, clause 421 at page 46. Now, 421, the relevant information as per the format is at page 74. Information on current litigation in which the bidder is involved. In the format, they put current information, current litigation. But page number 74, my lord.
Yes.
My lord, we filled it as per this format as is required by section 3. In my additional affidavit filed the other day, my lord, on the day when it was initially moved, at page, my lord, 389. It is nil. There is no current litigation. And the litigation which my learned friend refers to, my lord, are with respect of this same very department, my lord, and in respect of the same program, of the Vibrant Village program, not this package, in which, my lord, we had alleged that there certain persons were being favored on the basis of.
You're referring to which page?
Page 389, my lord, of the additional affidavit. Filed the other day, my lord. The full lit page, my lord.
Yes.
My lord, this is as per sorry, my lord, this is as per the format at page 74, as required by section 3, that we have to fill it in this format. Furthermore, my lord, I would like to ask myself, my lord, as to what would the past litigation which have been withdrawn as or closed, my lord, I have any bearing on my capability to carry out the works, my lord? They were in respect of the same very department, the same Vibrant Village program, where some recommend, if Lordship remembers, it was moved before Lordship, where there was a recommendation list by the former MLA.
I don't know, I'm a common man. If I want to take a house on rent,
My lord,
I would see that the landlord
my lord.
doesn't harass other tenants by regularly approaching the court.
My lord, but approaching this honorable court under 226 for my lord, for the protection of our fundamental rights, can that go against me, my lord? This is not any other litigation. What my learned friend refers.
It is their wisdom. They want to know whether you are litigating or not.
Yes, my lord. But in the format, they do not say so. And in Cartel Infotech, my lord, the Supreme Court is clear. If it is in a format, then we cannot be faulted for not filling up as per the format. Their format does not say about past litigation. Their format says about current litigation. And it is as per the format. Cartel is on that very same point, my lord. And we have not deviated from the format. It is their fault. For their fault, my lord, should we be prejudiced, my lord? And it is not that they do not know. It is against the same department, my lord, in respect of the same program. Then it's not any other department. The orders which my learned friend has produced, my lord, if Lordship goes through and Lordship looks at the names, they are the same respondents in all likelihood. But it is in respect of the same program under which this NIT is called, the Vibrant Village program. So it is not that they are unaware of. They are aware of.
Okay. Yes, Mr. Tarak.
My lord, 4.2I is clearly mentioned, page 46. Information regarding any litigation or arbitration during the last 5 years in which neither is involved. Party concerned, the dispute amount and matter. Now is taking the advantage of the format. It says that it is current.
Page 46, 4.2.I.
Yeah, yes, 4.I is clearly mentioned. Even in this package, there was a litigation by the petitioner. For this package also.
Yes.
So regarding ongoing commitment also, here furnish only 2 ongoing commitment. But there are another 2 which has been aborted recently in the same in present years. So then already he is undertaking 4 packages. Even the beach capacity also problem. So you cannot engage same set of machinery, same set of technical personnel in 4 packages, 4 projects at the same time. So there is a reasonable ground for rejection of this technical bit.
You have the documents for these 3 packages?
Well,
for these 3 tenders, you have the documents?
3 tender. For 2 package, I have submitted my lawyer, where he has been awarded 1. In case of 2, he has furnished in his existing commitment. In the writ petition.
Do you have a copy? No. I have provided that information as
Page 160 have furnished only for 2.
No other. No, we are not. Sure.
Page 160 here furnish only two ongoing projects.
Which is the-
You're saying that all these three bids were submitted on? What's the date? What is the date of submission of?
My lord, it was on 22nd of March, 2025. In my table, which I furnished today, the table 1, my lord, it is mentioned. Table 1, the dates are there. Table 2, my lord, the compliance documents. Table 1, my lord, petitioner's bid submitted on.
Anything else you want to say, Mr. Tarak? That's all?
Yes, my lord. Otherwise also, my lord, the NG projects. This is a infrastructure development works. So constitutional court has to be processed while issuing any stay order, since it will delay the project, since this project has already delayed by more than years because of the various litigations. Since from the beginning there was litigation.
My lord, I've just taken the instructions. We are carrying out only the 2 works which we have mentioned in page 160. Most probably what I have not seen the document which my learned friend has produced, but I have annexed one tender evaluation report, my lord, from page 378. Most probably it is in respect of that. That is what is current, my lord, now. Look at March. Order. Abhi diya hai. 13th March. 25th February. My lord. My lord, this is one, but my instruction, my lord, which I got just now, my lord. I've confirmed now, my lord. We are carrying out only these 2 works. That is what I have.
What was that? The page was, what was that page?
160.
160.
My. And in respect of the other bidders, the private respondents who have been found responsive, the other day I submitted, it's all on the basis of fake documents. How can they be awarded the work, my lord? When they, my lord, when the tax invoice of 2016 shows GST, my lord. GST came into force in 2017, 1st of July. And their document at page 375 of the petition, my lord, the tax invoice of 2016, it shows GST at 18%. That is clear, my lord, it's a fake document. And they are awarded the work, they are found responsive. Page 375, my lord. It's clear it's a fake document. How can they be awarded, my lord? My friend is relying on NG projects. But by NG projects doesn't say that you have to give it to persons who are relying on fake documents. We have not relied on any fake document. It is the private respondents who have and who have been found responsive. How can they be awarded the work, my lord, on the basis of NG projects? Can they be allowed to carry on the work? It's public infrastructure work. Page 375, if lordship comes to. I've not put that in the table, my lord, but page 375. And my learned friend was also supposed to take instructions, my lord, on respondent number 6, as to the whether the documents, what are the documents he has uploaded, my lord. There are no documents. My specific allegation, my lord, is that there are no documents uploaded. Respondent number 6, page 375, respondent number 7, and also from page 371, all fake documents, which they rely on in the tender, my lord.
No, at this stage, you only call for your records,
My lord,
not their records.
my lord. Their records, okay.
We have not issued a direction.
My lord, my lord, my lord.
Oh, no, respondent number 7 is also there.
Respondent 6 and 7 is private respondent.
No, the documents of 7 also you had called for.
7 and 6, my lord.
Not 6, 7.
7, my lord. These are fake documents. My lord.
Copy of the tender documents of respondent number 7.
Okay, that I could not add properly.
But these are downloaded from their portal, my lord.
Just ask them whether they can give it by the end of the day. Just ask your authorities if they can provide it by the end of the day.
It has to be downloaded.
In WhatsApp.
We don't need a printout. We just need to see those documents only, whether the documents which they are claiming to be fake, whether they are the same documents were uploaded.
That invoice, which
Yes, 9 series from page 371 to 375.
370.
371 to 375.
You can send it by mail, we can open it here and look into it.
It'll take maximum 5-10 minutes for them, my lord.
We don't know.
My lord, for them, my lord.
Who is, who may be assigned with what duty, we don't know.
My lord.
My lord, most of the time, these engineers, they are in mobiles.
Yeah, we understand. That's why we're asking you. Just ask them if they can provide us.
If
by the
it
end
can
of the day.
fix tomorrow.
Not tomorrow, my lord.
Tomorrow, you have difficulty. Everything has to be wound up by me and my sister. That's the difficulty. Just try to ask them, we take it up. My lord.
Just let me ask them.
My lord.
You can tell us at 2 o'clock.
My lord. The office staff will be there, my lord.
We don't know.
My lord.
We can't say.
My lord.
Departmental issues are there. We just see if it can be, by the end of the day also by mail, it can be, just view it deeply. Yes.
May it please your lordship. Your lordship, unlike other writ petition, quo warranto is PIL in nature, your lordship. So any person who is a bona fide person can, irrespective of whether his or her right is violated or not, he can redress the public injury, your lordship. So in this regard, I would like to take a reference of this book, this one, Durga Das Basu Constitutional Law, your lordship, in here.
DD Basu. Yes, please tell us, I'll remember it. Tell us.
Lordship, I would like to read out this one.
Please.
The concept of locus standi is inapplicable in a quo warranto proceeding, your lordship, where the application challenges the validity of an appointment of a public office. It is maintainable at the instance of any person, your lordship.
Okay.
whether any fundamental or other legal rights of such person has been infringed or not, provided he is not a man of straw set up by any someone else, Your Lordship. So by virtue of this itself, this application is maintainable per se.
So next time when you move a matter, you remember this.
Yes, Your
Correct.
Lordship.
Let this be a lesson for you. Yes, now you tell us.
Yes, my lord,
This is something we wanted from the petitioner. And therefore, we adjourned the matter on that day.
yes, because my lord, he doesn't have locus even. And
He's right. In a quo warranto, you don't need it.
okay, because he has also not given his
Now,
personal.
just tell me, if I give always a horrible example, correct?
Yes.
Now, you go to a particular office and you find that somebody is sitting as a chief engineer. But you know this man, you know that he never studied engineering. He was a art student, and how he can go and sit there? Can't you make a challenge by which authority is sitting there? So he's right. Correct. So you shall notice. But next time be prepared. Correct.
Yes, Your Lordship.
You're a young lawyer, and when you move the court, before that, be sure with the basic fundamentals. Correct.
Sure.
Yes. Okay. Third. Mr. P. Wangpan, running counsel for the petitioner. Also heard. Miss.
Jasmine on behalf of the SGI M. Karthik.
Just speak it loudly, she can catch it. No, it presents. So, then counsel appearing on behalf of Mr. M. Kato, on a DSGI, respondent number 1, and Mr. G. Lolen.
Yes, my lord. I am for only
Counsel for
two.
respondent number 2. Next one. By filing this writ of quo warranto on Article 226 of the Constitution of India, the petitioner has prayed for quashing of the appointment of respondent number 5 as professor in National Institute of Technology with from Arunachal Pradesh, within bracket NIT for short. It is projected that pursuant to advertisement dated 16/6/2022 for filling up the post of faculty the meeting of the Board of Governors of NIT, Arunachal Pradesh. Was held. And as per the minutes dated 2/2/2022, the name of the respondent, number 5, was not found mentioned. It is also alleged that the respondent number 5 does not possess the requisite 10 to 13 years of teaching experience at any recognized central or the state government educational institution for the post of professor, and therefore, as his teaching experience in private institutions from the year 2003 to 2019 does not, is not as per the recruitment rules. The petitioner has received the set appointment. Next one. The learned counsel for respondent number 2 has raised a preliminary objection as to the maintainability of this writ petition on the ground that the petitioner has no locus standi to assail the appointment of respondent number 5, as he was never an aspirant to the said post. And he is not seeking any relief for himself. Stop. Next part in this regard, we mentioned that the said preliminary issue was recorded by this court in the order dated 8/4/2025. Next part. Project in order to assert that the writ of quo warranto was maintainable, even if the petitioner was not an aspirant to the set for the post of professor, it is submitted that a writ of quo warranto is akin to public interest litigation. And if the petitioner can satisfy that the person holding the post is not qualified, the writ petition will be maintainable. Next one. In view of the said submissions, the objection, objection as to maintainability is not found sustainable. Next, accordingly, issue notice returned over in 4 weeks, because it extra copies of as the learned counsel representing respondent number 1 and respondent numbers 2 and 3 have accepted notice requisite extra copies of the writ petition be served on them for respondent numbers 1 and 3. The petitioner shall take steps within 2 days for service of notice on the respondent numbers 4 to 8 by registered post with AD. First of the notice is made returnable on. Give a date after 5 weeks. Returnable on so and so. As per the only counsel for the petitioner is at liberty to collect the postal receipt number from the registry and to submit postal track report prior to the next date of listing. Next for that. List on so and so.
Much obliged.
May I please? There is some inadvertent mistake in the post title of my petition, Lordship. So kindly I will be allowed to correct that post title. Lordship.
Post title is mistake.
Lordship.
Okay. Your name?
D cycle.
So D cycle and counsel for the petitioner submits that there's an inadvertent error in the post title and therefore he placed that. Placed allowed him to make correction in the post title. Next one. Mr. Pichai, you are appearing for?
Respondent number 1, 2, and 4.
So, Lee Pichai, standing counsel for respondent number 1, 2, 3, 1, 2, and 4.
4. And
as well as this is Agasad and counsel for government advocate for respondent number 4. No, you are for 3. For 3 is CGC is not there.
you see on a Northeastern Council, it is a Northeastern Council, whether the
NEC.
But this is Government of India.
Government of India, yes.
So, next, the land counsel for the petitioner shall submit a fresh typed out copy of the cost cycle to the registry. To the deputy registrar, judicial, for being incorporated in the rate petition, and that will matter be listed again in the motion column. Next, in the meantime, the land counsel for the petitioner shall also serve an advance copy of this rate petition to the learned DSGI in respect of respondent of 5.
Lordship, item number 7, 8, 9, 10 is also analogous. Same. Lordship, can it be fixed on 22nd of April?
Whenever you do it, it will come.
Lordship.
Item number 5. Item numbers are
Item number 5, 7, 8, 9, and 10.
okay. Sure.
My lord, it's a bulky petition. I would not trouble my lord.
Before the old man.
I would not trouble my lord to turn the pages of it. It's a land acquisition. It's a writ petition because there is no award till date. That is why my lord the writ. The whole.
Notice then. We have only issued notice then.
My lord, there is a difficulty. I'll just place, my lord, very, very briefly. 1 or 2 things I will show to my lord. That is why some kind of my lord protection. It's a consolidated petition, actually, my lord, because there are 3 stretches. It is a matter pertaining to Trans-Arunachal Highway. My lord, it's a big matter, of course. Public interest is involved. Now, my lord, the 3 stretches are Lada to Sarli, approximately 60 km, Sarli to Huri, 78 km, and Huri to Taliha, approximately 27 km. In these 3 stretches, preliminary notification was issued. Followed by, my lord, final notification was issued. The unfortunate aspect, my lord, in this case is in all the 3 stretches, there was no ground survey, no notice to owners, no formality laid down in the statute has been followed. So, my lord, when the owners came to know that these things were done, and on ipse dixie, my lord, they have taken the names of the people. Many of them possibly are the relatives of the bureaucrats who are doing the work. So therefore, my lord, there was a protest, and then there were minutes. There was a meeting. Minutes of the meeting, my lord, these minutes are consolidated minutes pertaining to all the 3 stretches because of the uproar of the people. So involving all the three stretches, there was a meeting and minutes of the meeting, my lord, I'll take my lord straight away. This is page 470 of the writ petition.
Page
470. And my lord, one very important thing about this meeting is, of which minutes I am placing, minutes are dated 27th March 2025. Whereas, my lord, the final notification in all the three stretches were issued much earlier. So they themselves then had to realize the mistakes they committed. So 470, Lordship may see straight away. One page I'll just read, my lord.
What is your interim prayer?
My lord, I'll rather, my lord, the way they have put it, I would not put it this way. I'll simply say, my lord, at least after 9 days, my lord, again we are having the court. Let them produce the field survey, because in the minutes it was provided, at least the field survey should be carried out. After the minutes, the field survey was done of one particular stretch, and field survey reveals a different picture altogether. What about the field survey of the other two stretches? So at least, my lord, they should produce what have they done in terms of the minutes. If they publish an award, my lord, then the appeal. And those very people, my lord, whose names are not in the award again, where will they go? Then difficulties will arise. Lordship will just see only one page, the page of the minutes.
But if you see, if that is your case, then you will have to move the competent authority for inclusion of your names for the raising a objection as to the disbursement. But that will be before the deputy commissioner.
That
So
is,
that rate would not be maintainable.
but my lord, the difficulty is if the steps mandated by law, they are not followed. Because after the preliminary notification, A, B, C, there are requirements of issuing notice. If it is not done, if after the final notification required steps mandated by law are not taken, then my lord, entire process is vitiated, incurably vitiated.
Then,
How could there be award thereafter?
then it would be.
Because in minutes, my lord, there is an acknowledgement of the fact. That is why I am placing the minutes of the meeting.
Yes.
I'll just read, my lord. With reference to the letters dated above, in accordance with the minutes of the meeting as received from the office of the learned chief secretary, and in response to the status report as sought for from Director Land Management on 27th March 25 at 2 p.m. a board meeting was convened, which was chaired by the Deputy Commissioner of Kurung Kome District, Koloriang, to assess the latest status report of the Frontier Highway Land Acquisition, which falls under Section 23 of the LARR Act 2013. The meeting was attended by the administrative officers, HODs of the line department, board members, DLRSO, and other key officials. The Deputy Commissioner opened the floor for the board members to share the challenges faced in making the final award draft, owing to the time frame set by the government and the way forward. While the board members, DFO, DAO, DHO asserted that they have duly submitted and verified their assets on the latest draft submitted by DLRSO, EEPWD had still not verified the same. After the detailed discussion of all the board members, administrative officers and other officials regarding all the issues faced in the finalization of the draft, following decisions were made. 1. In lieu of concerns raised by the local representative and few interested landowners regarding the sanctity of the draft made, the team unanimously decided to carry out a field verification visit on 28th March, 29th March, and 30th March 25 to address any genuine concerns on ground with people and instill public confidence. The team, under the leadership of concerned administrative officer, consisting of TLRSO board members and LM staff, will visit the stretch to cross-verify the details submitted in the latest draft by DLRSO. And DLRSO, my lord, is the villain. In fact, we have made him a party in person. He has done lots of mischief. And to identify any potential issues related to the acquisition. The visit will rely on official records and surveys to ensure accurate verification. Board members assured that the verification process would begin from Sarli block. Secondly, the Deputy Commissioner has directed the team to compile and submit a detailed verified report regarding their findings from the field verification process. This will help in ensuring error-free finalization of the draft. This has not been done so far, my lord. It was also decided that all the genuine landowners will be intimated for the execution of an affidavit formed before the concerned executive magistrates to ensure that in the event of any complications, the same can be referred to as a proof of land ownership. This measure has been devised additionally to address the latest concerns prevailing, which has led to delay of the submission. Keeping in mind the timely and smooth execution of the project in future, the meeting concluded with collective agreement to move forward with the field visit and verification process and the report submission thereof. The Deputy Commissioner strictly reiterated the importance of conducting the verification efficiently and transparently, ensuring that the land acquisition proceeds without any further undue delay in future. Now, my lord, after this, there is a field verification, the field survey report of 2nd April 2025 from Huri to Taliha. This has come. One report pertaining to one particular stretch, Huri to Taliha, page 474.
474.
Yes.
Then
No, my lord.
something is very wrong.
So, my lord, after final, and my lord, what is the date of final notification? The date of final notification from Huri to Taliha is, my lord, final date I'm showing, the date is 30 August 2024. 30 August 2024, final notification was issued so far as this stretch is concerned. And now there is a field verification. So, cart before the horse. Or horse after the cart, whatever I may say. Entire thing is vitiated. So, my lord, what have they done? I only say, show us the field survey of other two stretches. The very next date. Everything is vitiated. How can they publish the award, my lord, like this? A short date, my lord, we will go for hearing on merit. The genuine people, my lord, their names are not there. I have been told the relations of DLRSO, his friends, people don't live in that locality. The people who don't live there, their names have been included in draft compensation. Draft compensation was prepared even before final notification. So, my lord, this is how things happen. So, my lord, page 474 is a testimony of the fact. It is illegal. The very procedure.
Yes, Mr. Radhan.
This project, National Highway project, madam.
Frontier Road project.
Yes, madam. It's a important project, madam. Land acquisitions and all, and has to be done as soon as
Then you have to
otherwise.
produce the preliminary notification, the claims and
Madam,
objections.
for that, I'll have to take instruction. What my concern today is that this honorable court may give us time to file affidavit or take instruction, but no way, because it's matter of compensation what they want. This compensation obviously the union.
Some people do not even know whether their names are there or not.
Yes, madam. That are first point, my lord will say there is no displacement, my lord. There is no displacement of any person. It's a vacant this land, my lord. Compensation, those who are the owners, they will obviously the union owners will get. Now to determine that how the government has proceeded, how the department has proceeded. My concern, my lord, is that
no.
This,
So then you see, then in this document, what you call the meeting minutes.
yes, this will be looked into.
No. In the meeting minutes, your deputy commissioner would have come and said that these are the list of beneficiaries.
Yes, my lord, this will be
Why
looked
they
into.
don't disclose it in the meeting? We call a meeting, but they don't disclose it.
My lord, this will be looked into. What my concern, my lord, for the welfare of the state is that this will be decided. Let me take instruction, but there should not be any stoppage to hand over the land, because ultimately who are the beneficiaries, there will be decided, my lord. And what amount of compensation will be because it's a time bound project and we have to hand over the land, my lord. The differences between what
No,
the
but
amount
how
and
do
all,
you assure
that should
that-
not be a
How will the state assure the court that the claims and objections which these people are having will be examined? But you see, the issue is that, let us say, petitioner number 1, he claims that out of this 5 plot of land, 1 is his. Tomorrow you extend the frontier highway to say this blue and green. Now, how do you come to know after that? How would you just tell me, how would you come to a finding that the land which was taken over, blue land taken over is of 1, now petition number 1, and green land which is taken is of the petition number 2? How would you do that
My lord,
exercise?
that's why, my lord. Till now, it's only in the process of acquisition, and the acquisition process and the handing over has to be done. Till now, there has been no further development. The execution will not start automatically, my lord. This process for handing over the land has to be completed, and thereafter only the tenders will be plotted. That will take time, my lord. What my concern is that at this stage, let the government not be stopped from handing over, because these are differences amongst the beneficiaries, and whether this will be chalked out, my lord, whether a proper survey was done or not. That our concern is that because of the differences within the beneficiaries, or the main thing, at least the process for handing over should not be stalled. Otherwise, it may get further delayed.
You see, data
Because
it's your
obviously before execution, starting the execution, construction of the road.
Before the final notification, this had to be done.
Yes, my lord, that instructions I'll take. But there cannot be a fear that if we hand over the land, there cannot be any other.
How do you deal with Article 300, capital A?
My lord, that is, my lord. There cannot be a fear that as soon as we hand over, there cannot be any measurement and also. The execution will take time. That is at least let our process for handing over that not be stopped, my lord. The union landowners will get their due compensation.
If the state thinks that nothing is going to happen in 10 days or 15 days, let for 15 days, no money be disbursed, and this land will not be handed over.
But that should not stop us from processing.
Very clear.
My lord, let me
Please come
take
to-
instructions, my lord.
Come to this Act. Right to fair compensation.
Lordship may take my copy. In fact, our pleaded case is this: preliminary notification steps thereafter not taken. Final notification steps thereafter not taken. On HCDC names have been included. And so far as the list is concerned, in fact,
First requirement, Mr. Ratan,
yes, ma'am.
is the determination of social impact.
Yeah.
Correct. That is there. After that, there will be a publication of the social impact study. Then it will be appraised by an expert committee under section 7.
Chapter 4, my lord, deals with
After
the
that, publication of preliminary notification.
11.
11.
Subsection 2, Lordship may see. Meeting has to be called.
Gram Sabha.
Gram Sabha has to be intimated. Section 11, subsection 2. No meeting, nothing happened. Even after publication of preliminary notification. Nothing. They cannot show from the record.
That instruction I'll have to receive, my lord.
No, you take it, but if I will make it clear that if this 11.2 is not complied with, then this notification will not be acted upon.
Then, my lord, section 12 also not complied with. No compliance of section 12. The first proviso and the second proviso. Section 12, first proviso, second proviso.
My lord, that whether it has been complied with
It's
or not.
okay, because then the order will not,
The field service
will not come against you. If you have done it, you go ahead. If you have not done it, then you don't go ahead.
And my lord, my only prayer is on the minutes made it clear that there should be field survey. One field survey report I have put to my lord.
We don't take cognizance of that. The reason is very simple. Let us say this happened. Then there is a public objection and they say, do it again. There may be eventuality, we don't know. But if this 11 and 12 is not complied with,
Not complied.
then you are saved. And if they
Let
have
them
done it,
produce, let
if
them
they have done
produce.
it, then they will proceed and then will tell us.
Let them produce it. Right?
We'll pass orders at 2 o'clock. We'll pass orders at 2 o'clock.
At 2.
So PK Tiwari, the senior counsel, assisted by Mr. L. Kamble, non counsel for the petitioners, as well as Mr. N. Ratan, done additional advocate general, assisted additional advocate general, appearing for respondent numbers. For all,
No, my lord. There are private respondents also at page 29, my lord. So course title. I will appear for 1, 2, 3, 4, and 5.
respondent numbers 1 to 5. Why so many other respondents are there?
Total number of private respondents, my lord.
Why so many respondents?
I beg your pardon, my lord.
Why so many respondents?
Because, my lord, in all the 3 stretches, all the persons like whose land, there are 2 categories of persons. Those whose land is there and those whose land is not there, but the names have been shown. So all those persons whose names have come, they have been made a party.
Whose names have come in the list of beneficiary.
Yes. Not verification, my lord, in the draft compensation, right? Because the draft compensation award was also made after the final notification.
All those persons' names are here.
Yes. Okay. That is it. That is it.
For the in brief, one of the case of the petitioners. Is that they have lands in the at various places in the stretch of number 1, LADA LADA to Sarli SARLI, number 2, Sarli to Huri HURI, number 3, Huri HURI, Huri to Taliha TALIHA, and the Kurum Kume district. The state respondents planning a frontier road. Highway, for frontier highway, in that stretch. It is projected that without compliance of the provisions of section 11 and 12 of the right to fair compensation and transparency in acquisition, rehabilitation and resettlement act, 2013. Not only a final notification for acquisition has been issued, but draft estimate compensation cost of the draft award has already been prepared, which envisages payment of compensation to the respondent numbers 6 to 710. It is projected that, however, the name of the petitioners have not been included. It is also projected that
So far as petitioners are concerned, there are two categories. Those petitioners whose names are there in draft compensation, but the property specification is not correct regarding the land measurement. And the second categories are of those whose names are not there at all in the draft compensation. So two categories.
Second category of petitioners. Second category of petitioners whose names are included.
Clarifying is the field survey which I have shown to your lordship. In that field survey, their names have come for the first time.
There are some petitioners have land, and the name of some petitioners appear in the draft compensation award. So, however, the lands have not been properly identified.
Lands and assets. Land and the assets.
Land and the assets not been properly identified. It is also projected that owing to various complaints made in this 3 stretch of highway, by landowners of 3 stretch of highway, the deputy commissioner, Kurum district had called a joint meeting, a joint board meeting on 27/3/2025 wherein it was decided, amongst others, that fresh field verification would be carried out on 28/3/2025, on 29/3/2025, and 30/3/2025. And detailed verified report with regard to the finding of field verification process would be prepared. Accordingly, by filing this declaration in Article 226 of the Constitution of India, the petitioners have challenged the land acquisition process, including the final notification and draft award as void ab initio. All the three stretch of the, in respect to land in all the three stretch of highways. And to direct the respondent authorities to initiate a fresh acquisition process by adherence to the Right to Fair So Act. And the manual for land acquisition in Arunachal Pradesh, 2022. Next, issue notice returnable. In how much time, Mr. Ratan?
After 2 weeks, madam.
2 weeks.
Yes, madam.
Give a date after 2 weeks. Returnable. Make it 3 weeks. Some 2 weeks will be too burdened.
Can we go for paper publication of all these?
First you'll have to take
I
note.
understand.
First you'll have to wait, then it
Yeah,
doesn't happen then.
Correct.
See, no, 30 is too short. No, after 2 weeks, 3rd week. 7/5/2025.
That might be too long, madam. Let it be on 26th April.
Huh?
26th of, oh, madam, 28th of April.
28th.
Yeah.
No, these 2 weeks we are overburdened. There are so many cases already listed. For last 2 weeks, we are doing same thing. All matters are being adjourned after vacation.
Madam, in that week, madam, commencing on 28th, madam, 1st of May.
1st of May.
Maybe it's the holiday.
No. Labor Act does not apply for us.
Secular socialist, so socialist is also there in the preamble. Socialist is also there in the preamble, so
No,
I thought maybe.
in this code, there are two classes of people. One is
Workmen.
people like me. The second class is yours. And again, in yours, there is a class distinction. You may not be doing it, but there are several other lawyers who are required to give hajira. Before, we don't know how classifications are made. Earlier, I used to give that hajira. So first me, I would remember, you may not remember.
Anyone doing civil practice is must.
First May. Okay. First May 2025. As the learned additional general accepts notice on behalf of respondent is 1 to 5, from a requisite extra copies of this revision be served on within 2 days. Next, petitioner shall take steps for service of notice on the private respondent numbers 62
710, I believe.
710.
710.
710 by registered post with AD. System. The shall take steps within 4 days. 4 days. For service of notice of the private respondents.
My lord, if you can.
10 days, my lord.
No,
One
10 days,
more-
Mr. Ratan is asking for, within 10 days it will be listed again. So your all effort will go. Your entire expenditure you will do will go in vain.
Oh, within 5 days, my lord. Oh,
So
zero.
we understand that we'll have to give another date because then first will be too low. We'll make it 14th of May then. You'll not be, I'll tell you, your entire effort will go to waste. There's a judgment of Hyderabad Alvin, which says service after due date is no service at all. So this, how many pages is this writ petition?
513.
Huh?
513.
513 into 700 is 35,000 pages. Correct.
My only concern is that.
No, that's okay. But no, we are not you from doing it. If you have done it, you go ahead.
Yes, ma'am.
And postage, say 100 rupees into 700 will be 10,000. So this amount of money will go to waste. It's your choice now. You must take a choice decision. Or not choice, what is it called?
Yes, my lord, we have made a party day, my lord. I need to, my lord, sir.
No, that's okay. But then we can't do a short date. 814, 525. Next one. Also, the petitioner is divided to collect the postal receipt number from the registry and to submit postal track report prior to the next listing. Next para. The learned senior counsel, the petitioner has prayed for interim relief, which is opposed by the learned additional advocate general on the ground that the Frontier Highway project is a essential infrastructure project for the country, which should.
But I'm only for the publication of award.
It's okay.
Because then petition becomes infructuous.
Which is essentially used. Will be
For
it
national
will essentially be
security.
used by the armed forces.
Yes, national security.
Let them work, but then without the award. They may proceed without the award.
That's good. With regard to the nature of work, and also taking into consideration the grievance of the petitioners that their names have not been included in the list of award. In the draft award, it is ordered that before actually taking over the land, actually taking the land for the construction work, the respondent authorities will videograph the entire stretch of land which would be taken over so that the identification, whether the land could be identified.
That before actually taking over, before initiating the execution of the work.
No, we are not saying those. Whatever you do. But before you take over the land, before you start actual construction, we'll have to videograph it and keep it because here we have a strange phenomenon. Applications for this award will come in 2 or 3 or 4 stages. First is land, then there will be Ziraat, then there will be construction, then there will be community rights.
Malot, can it be then even after handing over of the land before execution? Because we will have to hand over.
My lord, videography is must because I have already learned. That buildings have been shown.
We are not stopping you from doing anything. Before you
execute.
No.
Start the construction.
Why you are leaving the taking over? You want to screen your officers? No. Somebody is taking over the land.
Yes.
First, the land under the Acquisition Act will be taken over by the state government.
Yes, ma'am.
No, he does not want his responsibility to be taken. He takes over the land. You see, there is a time gap between land taking over and handing over.
Well, final notification has been.
No. Please try to understand. This I am taking over.
Yes, ma'am.
Correct. when I hand it over to you, by the time I have used this much, there's a 10 milliliter deficiency in this. Now, if I don't videograph the taking over, that is why you see when I bought this, it was in sealed pack. There was a sticker here. It is in sealed condition. I broke the seal and I used 10 ml of it. Now, can I go back to the shop and allege that there is 10 ml short when the seal is not there?
Well, in fact,
My lord, if the videography is done, there is going to be a big expose because I have been told there are vacant lands wherein the government buildings have been shown and crores have been shown as given to the department. We all know where the money will go.
my lord,
That's why videography is
these
must
are-
and manual provide for videography.
this will be subject to final notification has been done. No, only award has to be published, my lord. Final notification, meaning there were
After the final notification, you take over the land.
final
What is the
notification.
harm in doing a videography?
Final notification itself will amount to taking over the land, my lord. By final notification, we have to take
Look at this. Does it say final notification means deemed taking over of land? I don't think so.
It's a separate problem. Section 20 also.
38. Power to take possession will come only after award of the collector, it becomes final.
But my lord, section 20 also, after final notification.
my lord, section 19(1), my lord.
20 is land to be marked out, measured and planned.
Yes, after final notification.
38.
Okay.
Yes, sir.
Power to take possession.
After ensuring full payment.
My lord,
But here lies the
In-
problem in the payment itself.
yes, my lord, but
How the payment will go? After final notification, as per the manual, they have to do the entire exercise. Section 20 is also there.
No, that the additional information will satisfy himself. So technically, Mr. Unless the payment is made, you can't take over. And that is why this is the stage where I want that this videography be done.
Videography will send panic waves.
I don't
Nobody
know.
wants videography. Manual provides for videography.
Why not? We are having what you call open channel. Then we want videography.
Videography is provided not in the manual.
We don't know, but
I'm showing.
now the judiciary is adapting to video photography.
Yeah. I had seen it.
You know, Mr. Tiwari,
No.
I go slow. Therefore, after this video, what do you call? No.
The right of the
No,
manual.
no, what I'm saying is that since I'm slow and now we are in live streaming, I had to develop this to show to people that, well, this is an old man. He may go slow.
Para 8. Para 8. No, the extensively photographed, videographed. Third line, photograph, videograph.
Ground joint survey report. No, survey report is before award.
Lord, here there is no survey at all.
No, I don't know, but this
That's
manual,
why.
if you are saying, showing it is 8.
But at least videography is provided for in the scheme of things. They have never done anything.
Others may only observe that the government may go ahead, but the compensation will be.
No, go ahead, means you see, there are, you see, I have a very bad experience dealing in litigations here. In this, so many times I have come here.
Except for the compensation part, because my lord.
No, you see, the difficulty is in this bench that the land acquisition, can you deny that land acquisition claims do not come multiple times for the same plot of land?
Well, what our concern is, my concern
No,
is
you
that.
have a definite concern.
My lord, may I please? The central government is asking us to acquire and hand over the land.
But do it. I
yes.
said, do it tomorrow morning. Have I stopped you from doing it? But why will you not video photograph? The land is of Mr. Tarak or Mr. Nair sitting here. We don't know.
My lord, that may be made clear, my lord, so that otherwise.
Stopping you, have I passed any order till now to stop you from doing it? No.
My lord has also.
If you have the resources, do it tomorrow morning.
Not to proceed, my lord has
Have
observed.
I passed that? No. I have not said. Till now, I have not said that.
Otherwise, our concern is that we'll have to.
So do it. We are not restraining you, but you don't do it without following the due process. 11, 12, and this video photography, we don't do, don't process. Then
Yes,
there will be
if
a.
not done, my lord may observe that.
They are not stopping you from doing anything. What did I say last? Para? Aren't you satisfied? Let's go. First of all, in this regard, the concerned authorities shall also ensure that that in the process of land acquisition, which includes disbursement of the land acquisition compensation, the provisions of section 11 and 12 of the right to fair census has been scrupulously adhered to. Stop. Moreover, the videography of the entire stretch of land will also be conducted before actually taking out of the land, so that the nature of land, zirats, if any, existence of zirats, if any, and assets, if any, thereof, should also be captured. Next para. Insofar as the disbursement of compensation is concerned, the respondent authorities, especially the Deputy Commissioner from Kurunkamma district, before disbursing the disbursement, shall make public the joint verification report in respect of the land and the 3 stretch of frontier highway. And the field survey report as envisaged in the minutes of the board meeting dated 27/3/2025 shall also be produced before the court on the next date of listing. Specifically detailing the names of the persons whose lands are proposed to be utilized for the frontier highway. Next para. It is very clear that nothing contained in this order restrains the respondent authorities from carrying out the acquisition process and to continue with their proposed construction. Subject to adherence to the directions contained above.
Next date has been fixed on first of May.
It's on 14/5/2025. Sir, next, before that, the petitioner shall produce a certified copy of this order before the deputy commissioner, Kovin district. To bring the order to the notice of the said authority. Mr. Parme, please give a copy to Mr. Nathan also. Do we have this manual for land acquisition in the court? This manual for land acquisition? If not, we requisition for the time being and then return tomorrow.
I think somebody had sent me in a PDF file in WhatsApp. I will just try to find out and then it is his copy.
Huh? We don't have this. Then keep, make a copy and return it to Mr. Parme.
We'll make extra copies.
Hmm?
We'll make extra copies and give it to the High Court.
Okay. We don't want Mr. to spend money.
Well, he's rich. In this case, he'll become rich.
Mr. Parme, you are trapped.
My lord, it's same document which is also there. But other, according to them, they are of the opinion that GST was implemented in 2016. So that was their assumption. So in this regard, my lord, I want to place one judgment.
Yes.
That is from NG project, I will read it. This is page 141, para 16. Then 1, 2, 3. That is quoted from Jagdish Mandal.
Which one?
Page 141, para, sub para.
Which case? NG.
NG projects.
NG projects.
Yes. Para 16, sub para 3. Yes, and Jagdish Mandal.
Paragraph?
Paragraph 16, then it's up para 1, 2, 3, 22, sub para 22. Para 16, sub. This page 141.
Yes.
Thus in Jagdish Mandal versus State Orissa, this courts noted, married Mandal. Judicial review of administrative action is indeed to prevent arbitrariness, irrationality, unreasonableness, bias, and malafidus. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matters relating to tender or award of contract, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contract are essentially commercial functions. Principle of equity and natural justice stay at distance. If the decision relating to award of contract is bona fide and is in public interest, court will not, in exercise of power of judicial review, interfere even if procedural aberration or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest or to decide contractual dispute. So, my lord, here this case, the construction of road is a public interest. Since this project has already delayed by more than a year, so at the cost of the interest of the petitioners, Not that he have not got a contract, he have already got two contracts in the same divisions. And in another, when stay should not be given, that is National High Speed Railway Corporation Limited versus Monte Carlo. This is paragraph 48.
What is the citation? Because national, what you call this? Monte Carlo, there are 2 or 3 cases, which
Monte Carlo. This is
Yeah.
2022-6 SSC 401, page 401.
66401.
Para 48.
Four zero one.
401, yes. So I'm reading para 48, my lord.
Paragraph
48 for it.
Yes.
Even while entertaining the writ petition and or granting the stay which ultimately may delay the execution of the mega project, it must be remembered that it may seriously impede the execution of the project of public importance and disable the state and or its agency instrumentality from discharging the constitutional and legal obligation towards the citizens. Therefore, High Court should be extremely careful and circumspect in exercising discretionary while entertaining such petition and or while granting stay in such matter. Even in a case where High Court is of the prima facie opinion, the decision is such.
But just before that, in one of the paragraphs, you'll find mine may not tally with you.
Okay.
It is 43, maybe 1 or 2 paragraphs here or there.
43.
In that, the Jagdish Mandal is quoted. Para 22 of Jagdish Mandal is quoted.
Para 42 is in my 40.
Just pass it on.
My lord.
Just pass it on. Your book, please pass it on. Para 40. Para 28.5 of SCC. It quotes Central Coalfield and others. SCC 28.5. SCC 28.5, para 28.5. It quotes Central Coalfield and others. Down below thereafter. G.J. Fernandez and page 445.
No.
SSC. ये वही आपका Monte Carlo high speed. Yes, this is page 446, madam. No, this is page 444, 444, 444, yes, take this. 444. This Jagdish Mandal down is 48. So please read that part now. I missed it out here.
Oh, 42. Okay.
Jagdish
Yes,
Mandal, yes, 22, para 22.
Yes.
Page 444. Judicial review of administrative
Judicial
action.
review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafidus. Is proposed to check whether.
That's all. Yeah, that much.
Yeah.
So you see, if GST is not even come in 2016, if somebody is showing a document,
But, that is there.
where is the bona fide in that action?
No, that is there. There is wrong in assessment. According to they thought that is 2016 GST was implemented. So otherwise, the petitioner's case, there is a gallery error, which is very much clear, apparent in the place of the records, that ongoing commitments he has not furnished, and litigations he has not furnished, which is apparent in the face of the records. But here there may be some wrong assessment by the tendering authority. They have assumed that it was implemented 2016. That's what the instruction is. Otherwise, this is my lord, notice may be issued since this is, as I stated, this is already modern.
Yeah, 27 pass orders. But this will not be uploaded before tomorrow. Malo, it will not be uploaded before tomorrow. Malot, this is a short reply if Malot permits. Malot, insofar as my learned friend's submission that they assumed that GST was implemented in 2016 and therefore it is there. It clearly shows that this is the back. There's another issue to it. If they have wrongly made an error, they already have the residual power to make inquiry and they can cancel this if it is there. So this doesn't, this action can still be taken. My lord, but at that point of time, my lord, it was VAT. Do we understand? My lord. There is no mention of VAT in the document. So it's apparent it's a fake document. And also, not only one document, my lord. No, fake document, you see, determined at the time of awarding of the contract may not be possible. But when now you have pointed out, my lord, they can always make an inquiry. My lord, they have to, my lord. And the other submission, my lord, I have taken instructions from my instructing counsel, my lord, Mr. J. Sering. They are doing only 2 works. The other works, work order might have been issued but not served on us, my lord. We are not aware of those works. In anticipation, future anticipate, can my technical bid be rejected, my lord? We are not carrying out those works. We have not been awarded those works as yet.
They have signed a contract.
No, my lord. My specific instruction from the instructing council, my
I
lord,
have given-
that they have not done any other work other than the two.
It's shown you those two contracts.
Those- The specific instruction, my lord, is that only these two works at page 160. And yes, we have participated in another one, and I have annexed the technical evaluation report of the, my lord, at annexure.
These are the two.
My lord, annexure 13.
No.
No. My lord, one is. My lord, these are of the two works, my lord. Two works we have mentioned, my lord, at page one.
No, these are different.
Very different.
The amounts are different. I also don't know about this, but amounts I tariff are different. Look at the amount. One is
160
two to
is,
something.
160 is one is Perciparlo Road. One is coming.
I don't know. I would not know that stretch of road.
My lord, this was the specific instruction I
No, it's
took
okay.
once.
It's okay. It's okay. Okay. Not only can.
Deeply obliged.
In fact, my lord, in this case, on the last occasion, my lord, hearing was conducted since the my lord, exchange of pleading has completed. But thereafter, my lord, this court found that and accordingly, order was passed on 20 December 24, that the state need to file a affidavit, my lord. So, my lord, I have been informed that the conducting advocate, government advocate in this case is, my lord, out of station. So probably I have, so far that additional affidavit has not been filed. In fact, that additional affidavit was to question about that pertaining to the land allotment. If the land allotment is transferred under what?
Okay, I get it.
That was. So, my lord, the matter may be
You're not
taken
filed affidavit?
after 2 weeks, my lord.
You're not filed affidavit?
Yes, sir. In this conducting, advocate is not present today.
Okay. Mr. C. Modi, learned counsel for the petitioners, is present. Mr. Ms. P. Pangu, learned government advocate, has submitted that the learned government advocate to whom the matter is allotted is not available. And she prays for further two further weeks' time
Yes, sir.
to file affidavit as directed by order dated 20/12/2024. So the affidavit shall be filed within 2 weeks from. No, we'll make it. 2 weeks is a vacation in the meantime. Shall be filed within 28/4/2025. It's list on 30/4/2025.
At the same time, my lord, I have same prayer in the item number 35 also, my lord. Since the council from the government is not available, so my lord, okay, waiting, no point of waiting to item number 35, my lord.
35.
After 2 weeks.
Only the affidavit is not there. Conducting counsel is out of station. It is not available. You could pay for journal meet. Prayer is allowed. List after 2 weeks. Item number 17.
My lord, in item number 17, I'm appearing virtually.
Yes.
My lord, in this case, I need some time to file an affidavit because there was I said that there was this issue regarding whether royalty is a tax. That matter has been decided. But if export royalty is no tax. So in that pretext, one GST is applicable. But this present case, that case was for under the act, under this mainly section 9 of the Minerals and Mines Development Regulation Act. Here the matter relates to, my lord, this
Principle will be same.
Relates to oil
Yeah.
fields, my lord. They had been
It's a oil
detached
field
from the main
regulation.
application. My lord, for the oil fields decision, because it pertains to entry 53 of list 1, they had been detached from the main matter, and now that matter is pending before the Supreme Court for final adjudication, my lord, for final hearing.
Oh, entry 53 has been segregated.
My lord, entry 53 of list 1, my lord.
It's still pending in the Supreme Court.
My lord, it is pending in the Supreme Court.
Can they provide the number, ma'am?
Do you have the number? This council.
Yes,
for
my lord, I
GST
have it. It is WPC 232 of 2020. It's a transfer case of Oil India Limited
okay.
versus the state of Assam.
Okay. Your name?
My lord, Tania Roy.
Priti Rao, I'm a counsel for the petitioners, has submitted that the issue of royalty in respect of oil field,
Oil field.
which is covered by entry 53 of list 1 of schedule 7, of 7 schedule. Stop. It is submitted that in the bunch of cases which was heard by the Supreme Court of India on royalty relating to mines and minerals within bracket development, what is it called? MMDR, the Development and Regulation Bracket Act, was segregated and heard by the Supreme Court of India. But the matter relating to entry 53 of list 1 of schedule of 7 schedule to the Constitution of India, in which the lead case is WPC. What is the number?
232. Malak, it's a transfer case. It will be
Yes, yes.
transfer case civil number 232 of 2020.
Transferred WPC.
Yes, my lord. Transfer case.
Which is pending for disposal before the Supreme Court of India. Accordingly, it is submitted that as the same issue is involved in the present writ petition, the verdict of the Supreme Court of India be awaited. Next. Stanley Borodan, Stanley Kosi for the GST. This was I'm trying to obtain instructions and to address the court as to whether the issues in this writ petition is pending before the Supreme Court of India. Next paragraph is P. Tangur, government advocate, and Mr. You are just your name. So for Mr. For Sam Cartoon, the DSG is present. Next paragraph, matter stands adjourned today. We're listing it after 4 weeks.
My lord, if in the meantime one humble prayer that the stay order could be extended, my lord.
Okay, list after 4 weeks. Interim order passed to this stands extended to the next set of listing.
Okay.
Here's one of the number which you say that a transfer petition civil is not showing up with its party's name. Different, it's a different.
Huh?
The case number is not matching.
It will be
WPC 232
transfer case civil number, not WPC number. It will be transfer case civil number 232 of 2020.
It will be transfer petition civil.
Transferred case. Two options will be there. One will be transfer petition,
yes.
other will be transferred case.
Yes,
If you go for transferred case, you will get it.
Okay.
Transfer case number 232. Okay.
My lord.
Yes, my lords.
Getting it?
Transfer case.
Okay.
Grateful, my lord.
My lord, yes, my lord.
May I, Your Lordship? Lordship, the petitioner is aggrieved by the decisions and recommendation of the DPC and appointment of private respondent to the post of MTS, Your Lordship. Private respondent number 4, who is a private, was a contingency staff and being junior to petitioner, she has been appointed, Your Lordship. Last occasion also, despite there being a clear-cut office memorandum for maintaining seniority list, the authority has not maintained that list. Your
No, but
Lordship.
they are saying that there are two separate lists.
Yes, Your Lordship, in their affidavit, apart from the mayor's statement, they are saying it's alternate basis. That cannot be, Your Lordship. Because as per the OM, there's no such rules.
This is
wherein-
the OM.
Your Lordship.
Which page is that OM?
OM is in page number, Your Lordship. Annexure 4, page number 33, Your Lordship. 33, Your Lordship. Annexure 4. This is the office memorandum dated 9 January 2012. Subject procedure for maintenance of common seniority list for skilled and unskilled contingency staff, Your Lordship.
You've got any document showing the decision of the government to have seniority list maintained for MTS and casuals?
No, Your Lordship. What they are saying that they have also maintained the office memorandum, but since ALC is not there in the memorandum, just to have a combined seniority list of skilled and unskilled contingency staff. So they have maintained separate seniority list of ALC.
But it must be backed by some rules on.
Yes, yes. There is no such provision there.
Then this has to be questioned. Authorities will have to revisit.
Yes.
Seniority has to be maintained from the date of joining, Your Lordship.
But you're yourself producing this page 80. Page 80.
80.
80. This gadget shows that it will be common list.
Yeah, it has to be common.
Then the action of maintaining a two list is.
Affidavit filed by the administrative reform, they have clarified that it has to be common seniority list.
This is. Yours is which department?
This is under Deputy Commissioner.
Under Deputy Commissioner, Your Lordship.
District Administration.
And there is a rule RR for multitasking staff, Your Lordship. And without in contravention of the existing statutory rules, they have appointed respondent number 4, Your Lordship. Whereas I'm eligible, Your Lordship.
Then we are sending this matter to the Department of Administrative Reforms to examine the authenticity of this, the propriety of maintaining two seniority lists in light of the office memorandum dated 9 January 2012. And to take a decision on the appointment of respondent number
4, Your Lordship.
4.
Yes.
Lordship, I have annexed the notification also. That is 13 July 2021, Your Lordship. Next, annexure 6, Your Lordship.
13
Or
July.
annexure 5, page number 35. For appointment to the post of MPS, it is governed by this rule, Your Lordship, recruitment rule. Paragraph number 2, Your Lordship.
So if it is 50%, then it will be rotation basis.
No, Your Lordship, it says 50% vacancies shall be filled from amongst the serving unskilled contingency / auxiliary labor corps. That means there has to be common seniority list, Your Lordship, for the both ALCs and contingency staff, Your Lordship, which they have not done, Your Lordship.
Okay.
And they're saying that there is separate seniority list for ALC and then contingency staff.
Essentially, we are sending this matter to respondent number 1.
Yes, Lordship.
The reason is very simple. If we disturb the separate, if by order of the court, we disturb the separate seniority list, there will be many people who will be who may be affected, who are not parties before us. Correct?
But Your Lordship,
No. It's not only answer to your issue.
Lordship.
It will have a ripple effect on everyone.
Lordship.
So therefore, it will not be advisable for the court to make that change or to order a change for one person so that it affects all people who are there. So it is better for the authorities to
Yes.
take a call. This-
If Your Lordship may see the reply filed by the AR. AR also they have stated that seniority list, Lordship.
The order would not be lawful order. You see, for the petitioner, we do it. What happens to that list then? It goes, two separate list goes. There are many people in that list who will be affected by that.
Lordship.
Correct.
Lordship.
Those are not parties before us.
The respondent number 2 and 3 in their statement, they have stated that.
Whatever they do, but you see, we are disturbing a seniority list where there are several persons who are not before us. So we are making a change in their position without hearing them.
But action of the respondent has done in contravention of this notification.
Let
as
the
well as
government take a
office-
decision. Let the government take a decision. If we take it, then we have to hear everyone. Every person who would be affected by that change in the seniority list would have to be heard, at least given a notice. Heard. It's an unusual and counsel for the petitioner. Also heard. Sahaba said on it, government advocate appearing for the Yes, I was commented, we're appealing for the respondent numbers 1, 2, and 3. Next one. Although the notice, although as per an order dated 28/2/2025, notice on the respondent number 4 is, it was accepted to be duly served, none appears on call for respondent number 4. Next paragraph. The petitioner is serving as a contingent peon in the official residence of the subdivisional officer within bracket civil, bracket Ruskin, RUKSIN, East Siang district, Arunachal Pradesh, and claims to have rendered more than 18 years of continuous service since 1/6/2006. Full stop. Next, the case projected by the petitioner is that the first line only, the earlier was of the petition. By referring to document annexed to this writ petition, has projected that the respondent number 4 was appointed by an order dated 11/9/2006 as auxiliary labor for CURPS, within bracket ALC for short. By the Deputy Commissioner from East Siang District, from Pasighat. Next one. The case of the petitioner is that by virtue of an office memorandum dated 9/1/2012, issued by the Department of Administrative Reforms, Government of Arunachal Pradesh.
This Lordship, this order has been issued by Chief Secretary, Your Lordship. Chief Secretary, Your Lordship.
Oh, acha. By the order, office memorandum dated 9/1/2012. There's something wrong.
Lordship.
Something wrong, it can't be. Page 33 and 34 appears to be unconnected. The reason is you have also produced, let us check this. Okay. Office memorandum dated 9/January/2012, issued under this signature of the Chief Secretary to the Government of Arunachal Pradesh under the comma Purportedly under the Department of Administrative Reforms, Government of Arunachal Pradesh, which was published in the Gazette on 19/1/2012, amongst others, all the departments, public appointing authorities were required to maintain a common list of the register of serving contingent staff, which invariably should include both the skilled and unskilled serving contingent staff in their departments, public offices, in order of their date of joining as such staff. Accordingly, it is submitted by the Learned Counsel for the petitioner that both the categories of staff and also contingent staff like contingency peon, the post which the petitioner is holding, and the other contingent staff who are called auxiliary labor corps, the bracket ALC for short, which the respondent who is holding, are required to be entered in a common seniority list. First off, the nuance of the petitioner is that the establishment of the deputy commissioner Pasighat is maintaining separate seniority list of ALC and which is the contingency staff, which page? ALC is page 42, contingency is where?
Your Lordship, that is in annexure 6, page number 42.
That is ALC.
But if
Beyond, where is that? Beyond?
Your Lordship, in the heading they have written ALC, but in the entire list it's a combined. Some are LC, some are contingency peons, Lordship.
Acha, okay. Then I am wrong. So accordingly submitted by referring to annexure 6 to the writ petition that the establishment of the deputy commissioner, Pasighat, had maintained a common seniority list of ALCs. But this is written ALC.
Yes, Your Lordship. But in the list, it can be seen, Your Lordship. Say, for example, Lordship, serial number 42, contingency peon. Serial number 44, LC. Again, me, myself, serial number 47, contingency staff.
So however, this said list also contains the persons who are appointed as contingency staff, helper, and contingency peon. Next one. In the meeting of the DPC committee, which was held on 11/12/2023, for promotion to driver of the MTS and regularization of UDC, held in the office of the Deputy Commissioner from East Siang District, the respondent number 4 was promoted to MTS within bracket peon on seniority cum merit basis on the retirement of Mrs. Oni, DOMIG, draftee, DRAFTY on 29/2/2024. Also, agreed by the said minutes dated 11/12/2023 and the consequential office order dated 8/3/2024. The petitioner had submitted a representation on 26/8/2024. And there is no, as it did not receive any favorable response from the present petition has been filed under Article 226 of the Constitution of India. Next one. Who is respondent 2 and 3?
2 and 3 is
DC
Deputy Commissioner, Your Lordship.
Deputy Commissioner M.
2 is Chairman cum Deputy Commissioner. Respondent number 3 is Deputy Commissioner, Your Lordship. EPC was headed by Deputy Commissioner, Mr. Chairman.
Does your name appear in page 88?
Your Lordship.
Does your name appear in page 88? No.
Yes, in serial number 3, Lordship.
Serial number 3.
Jimmy Perme.
Next one. The learned government advocate has referred to the affidavit in opposition filed by the respondent number 1, wherein it is stated that a common seniority list was required to be maintained pursuant to the OM dated 9/1/2012. Read with corrigendum dated 2/3/2012. Read with another notification dated 13/7/2021. Stop. However, it is submitted that in the affidavit in opposition filed by respondent number 2 and 3, the said respondents have taken a stand that the OM dated 9/1/2012 only refers to the common seniority list of skilled and unskilled contingency staff. And that there is no requirement. And it said OM for a combined seniority list, which include ALC and contingent staff. And it is stated that the petitioner is a contingency staff, whereas the respondent number 4 is an ALC. It is also submitted that as per the said affidavit, there's a continuing practice in the establishment of the Deputy Commissioner, East District, that the recommendation of the regularization of contingency staff and ALC staff are done on alternative basis, considering the seniority and educational qualification of the candidates. It's submitted that it is further stated that this time, on this occasion, i.e. on 11/12/2023, the ALC staff were considered for promotion to the post of multitasking staff. And on the next exercise, on the next time, the cases of contingency staff would be considered for promotion to the post of MTS. Accordingly, the government is opposed the player made in this petition. Next paragraph. In light of the stand taken by the Deputy Commissioner from East Siang District, that the OM dated 9/12 9/1/2012 has not provided for maintaining a common seniority list of ALC and contingency staff. Post of however, in the seniority list, combined seniority list is annexed to the writ petition. Your name is in this page
Serial-
42. Which page was your name?
My name is at serial number 47, page number 44, Your Lordship. Serial number 47, I'm at serial
47.
number 47. And it's just 6.
Yes. But your name is not there in their seniority list. At page 82.
Page 82, Your Lordship. That is the seniority list of ALC, Your Lordship.
No, I understand. This is also ALC, but inside your name is there. But the but this Deputy Commissioner files one where your name is not there.
Yes, Your Lordship. They says says this is the LC.
No, but if they are not maintaining it, how do you got this page 42?
Even private respondent name is also not there in the list, which they have annexed. In their statement, they have stated that private respondent name is its serial number 43, but your lordship can see page number in their affidavit. Serial number 43 is someone Sri Bir Bahadur Sonar 3, your lordship.
Yes.
Even private respondent name is also not there.
Oh, where is the statement?
Your lordship, it's paragraph number 9, your lordship. Paragraph number 9, last line, your lordship. This time, that is on 11/12/2023, last line, your lordship. This time, that is on 11/12/2023, the board considered a case on the basis of seniority list of ALC available in the office. The practice to recommend regularization of contingencies of ALC staffs are alternate basis, considering the seniority and educational qualification of candidates. As per the draft seniority list of ALC published, the private respondent name figures at serial number 43, your lordship. Srimati Motor Dini. Annexure C.
Oh, what is the name, Srimati?
Srimati Motor Dini, your lordship. But at serial number 43, in the entire list, her name is not there, your lordship.
This name's new to me, I forget. Name is, I'll just open the cost title.
In the cost title, it's
yes,
Motor.
I got it now. I got it.
They are saying this is the list of LC, but even the private respondent name is also not there. So which list they are maintaining, lordship, that is?
In the common seniority list, annex to the rate pressure is annexure 6, comma. The name of the petitioner appears at serial number
47, your lordship. 47.
47.
Yes, your lordship. Page number 44.
47. And the name of the respondent before appears at
48.
serial number 48.
Lordship.
Full stop. However, in paragraph 9 of the affidavit in opposition filed by respondent numbers 2 and 3, there is a categorical statement that in the seniority list annexed as annexure 3C, for the ALCs, comma, the name of the respondent number 3, the fourth, namely Srimati Motor, MOTOR, Motor DINI, appears at serial number 43. And then the separate list of contingency of East Siang district is annexed as annexure D. First off, on a perusal of annexure C to the affidavit in opposition filed by respondent numbers 2 and 3, comma, the name of respondent number 4, namely Srimati Motor Dini, does not appear. First off, however, the name appearing at serial number 43 within bracket page 83 bracket closed is Sri BIR. Next is BDR full stop. Sonar dash Roman 3. Whose date of birth is 25/5/1990. Date of appointment is 1/7/2007. is shown to be class 10 past and is posted at the DC office on Pasighat. First, the learned counsel for the petitioner submitted that she has gone through all the 115 entries contained in Annexure C. But she has not been able to find out the name of the respondent number 4. So she also states that now it is also seen that in Annexure D to the said affidavit, which is a seniority list of contingency within Packet District Administration, Packet was of East Siang District. The name of the petitioner appears at serial number 3. The date of birth is 5/7/1980. Date of appointment being 10/2/2006. It's shown to be class 10 past. Place of posting as Ruksin, RUKSIN. Remarked as unskilled. Full stop. Next slide. There's another aspect in this matter. The court is to accept this projection made by the petitioner that the common seniority list as envisaged in OM dated 9/1/2012 should also include ALCs, contingency peon, helper and contingency staff. And if on the assumption that the OM dated 9/1/2012 does not direct a common seniority list of contingency staff with the ALC. The establishment of the Deputy Commissioner, East Siang District, maintaining 2 separate seniority lists. Any directions in respect of the petitioner would have a ripple effect on the persons whose name are entered in the separate seniority list for ALC and contingency staff. Next, therefore, as this matter relates to the maintenance of a common seniority list of all contingency staff in all the departments. The genesis of which is referable to the office memorandum dated 9/1/2012 issued by the Department of Administrative Reforms, Government of Arunachal Pradesh. This code deems it appropriate to refer the matter to the Department of Administrative Reforms, Government of Arunachal Pradesh. Call for the records from the establishment of the Deputy Commissioner, East Siang District, Pasighat, relating to maintenance of separate seniority lists for ALC and contingency staff. And thereafter to examine the maintenance of, no, well, examine the correctness or otherwise of the maintenance of two separate seniority lists, one for ALC and one for contingency staff, in light of the office memorandum dated 9/1/2012. Stop. While doing so, he said, the concerned authorities shall also take note of the fact that in the affidavit in opposition filed by, in annexure C to the affidavit in opposition filed by respondent numbers 2 and 3, the name of the private respondent does not appear. At serial number 43. Next paragraph. In light of the discussions above and view of the and the view expressed by this court, the court is inclined to relegate the petitioner to the Department of Administrative Reforms, or Government of Arunachal Pradesh. First of it is provided that the petitioner shall submit a representation to the Department of Administrative Reforms, Government of Arunachal Pradesh, along with a certified copy of this order, prepared within a period of 3 weeks. Within 3 weeks. First of the petitioner shall also provide a photocopy of the affidavit in opposition filed by respondent number 3 as enclosure to her representation, along with copy of office memorandum dated 9/1/2012. Notification dated 13/7/2021. Just to enable the said authority to take a consider decision on 2 points. First, as to whether the maintenance of two seniority lists, one for ALC and one for contingency staff, in the establishment of the Deputy Commissioner, East Siang District is permissible in light of poem dated 9/1/2012. Next paragraph second, as to whether the name of the private respondent appears at serial number 3 of the seniority list for ALC as appended to the affidavit in opposition filed by the respondent number 2 and 3 by examining the appropriate records of the said establishment of the Deputy Commissioner of East Siang District, Pasighat. Number 3, whether in terms of the office memorandum dated 9/1/2012, the Deputy Commissioner, East Siang District, and the selection board constituted by him should have recommended the name of the petitioner as for regularization based on the parameters laid down in the OM dated 9/1/2012. Next paragraph, please. Court hopes and trusts that the Department of Administrative Reforms, Government of Arunachal Pradesh, shall take a decision in the matter within a period of 6 weeks. Next one, in the event the said authority deems it appropriate to give an opportunity of making referendum. Don't say that. You say just on receipt of the certified copy of the order along with the representation of the petitioner, the Department of Administrative Reform shall give an opportunity to the respondent number 4, namely Motordini, to submit a representation, and to the Deputy Commissioner from ICN District to clarify his position, and thereafter take a decision within a preferably within a period of 2 months from the date of receipt of certified copy of the order. Next one, the petition stands out to the extent is indicated above. There shall be no orders to post.
Obliged.
Anything I have missed out or is required to be added?
No, Your Lordship.
It's okay.
My lordship, respondent number not yet filed affidavit, lordship.
Respondent number 2. Yes, who pays for the private respondent? Pardon me, speak loudly.
Your Lordship, I have not given any instruction. I have not received any instruction.
Yes, okay. Affidavit in opposition is filed by respondent number 2. Make your submissions. What do you want to say?
My lordship, affidavit, I have not yet received, lordship. I have not received affidavit, lordship.
Affidavit in opposition is filed by respondent number 2. Copy is received by you.
No, lordship, I have no copy of affidavit, lordship.
Signature is written I BAM.
Lordship, it's
Once you, it is your signature, right?
No, no, Lordship. Lordship, I have not yet received, Lordship.
Whose signature is that?
Lordship, I didn't recognize it, Lordship.
Whose signature?
Yes, it's written IBAM, Lordship, but it's not our associate, Lordship.
Huh?
It's written IBAM, but IBAM is not our associate, Lordship.
Strange. We can't go on like that. You must know your brief. Now you lodge an FIR against this IBAM advocate.
Yeah, 107.
Look at the name IBAM is there in the first page. Why don't you look at it?
107. Lordship, case number is different.
Oh, it's a different case.
Lordship. It's 104, Lordship. It's 107.
Hmm. Yeah, well. हाँ? चलो क्या करा है? अब देख लिया तुझे? जो कॉल करते हुए देख लेंगे ना? Some different record is there. Okay. What says the representative? So how incorrect records have been placed before the court. So accordingly, matters to adjourn today. Let's start the answering occasion on a date to be fixed by the registry. Oh no, we can't pass any order. There's no order sheet.
But if there is an interim order, it may be continued.
No, the record is not there. So we can't pass any order. It just return. The court master will just return it. It's not the correct records.
Obliged.
सीएस में क्या करेंगे? सीएस में क्या करेंगे? हैं? जाएगा नहीं, रिकॉर्ड नहीं है। सही incorrect records have been incorrect records have been placed before. Which is not as per the cause list. Accordingly, matter stands return to the section. However, we don't consider the petitioner submit that there is an interim order. It said interim order shall stand extended till the next date of this. Yes, this is 28.
Your Lordship, I'm for the respond number 3. We are not going to file affidavit on opposition.
You're filing.
We are not going to file.
You're not going to file.
Yes.
Okay. May I, Your Lordship?
Yes.
Yeah, in that case, if respondent number 3, they are not filing an affidavit, on relying affidavit number 1 and 2, filed by the respondent number 1, on the perusal of that affidavit, if necessary, we'll file a rejoinder on the next date.
Yes, she's saying she's not responding.
So on the respondent number 1 and 2, their affidavit is already filed.
Yes.
On that basis, like if necessary, I'll file a rejoinder on the next date.
Okay. The learned counsel for the petitioner prays for some time to file, prays for is granted 2 weeks time to file rejoinder affidavit against the affidavit in opposition filed by respondent number 2. Next paragraph. Miss
Sonam Somo, S. Thomo.
Somo, TSOMO, learned counsel for respondent number 3. Upon instructions, has submitted that Respondent 3 is not filing an affidavit in opposition. Next one. List after 3 weeks.
Your Lordship, there is an interim order that may be continued.
List after 3 weeks. So the interim order passed today, so it's extended to the next floor.
Highly obliged.
May I, Lord?
Yes.
Your Lordship, in this matter, the petitioner does not want to press the matter further. Therefore, on the instruction of the petitioner, I want to withdraw the petition.
Your name?
L. Tatam.
On instructions from Mr. L. Tatam, Learned Counsel for the petitioner. Submits that he is instructed not to pursue the matter. Next, accordingly, this petition stands closed, having not been pressed. The observations made in this, made in the order dated 24/12/2024, that the work in question shall be subject to outcome of the present proceedings, stands vacated.
Much obliged.
Item number 30 and 31.
My lord, I'm appearing for the respondent number 7 in 31, my lord. And he has filed this application for vacating the stay, which is listed in 30.
Yes.
My lord, this is, your lordship may remotely recollect, my lord, because this is arising out of a land acquisition proceedings, my lord. And the same award and the notification has been upheld by your lordship sitting in a division bench, my lord. So this order was passed in May last year, and thereafter in November, the division bench order has come, my lord. So, my lord, I am saying, my lord, because it will take some time. So if your lordship permit us, because today I'm appearing virtually, my lord, it is always an honor to appear before your lordship physically. 21st, my lord, I will be appearing before the court, my lord, at Itanagar, just after the vacation, my lord. If it can be placed, because it might 21st.
21st will be very difficult to manage, because all these 2 weeks we have been adjourning matters after this view vacation.
Very
so
well.
21st will be some difficulty in listing. There are many matters, Mr. Viswas.
Very well, my lord.
There are many matters which are coming up. You can choose any date after 1st of May will accommodate.
1st of May, my lord.
After 1st of May, any day you choose, we'll give it to you.
Very well, my lord. Very well. My lord, lordship may fix it on 2nd of May, my lord, because today it will take some time. That's why I'm not progressing, my lord, because it will take at least 40-45 minutes. I just have to show you lordship some orders. So hardly any time is left. So 2nd of or 1st of May is okay, my lord, with me, for 2nd of May. Any date convenient to your lordship.
Yes, Mr. Pichar.
My lord, can it be on, my lord, 14th of May, my lord? 14th of May, my lord.
14?
Yes, my lord.
There is a interim order.
Any difficulty? First and second?
My lord.
Any difficulty in 1st or 2nd?
No, my lord, there's no difficulty.
So in these 2 days, take it, because he'll be coming from auto station.
My lord.
Mr. Viswas is.
If my learned friend agrees,
1st of May or 2nd of May, whatever choice you take.
5th of May, my lord.
Mr. Viswas, 5th of May?
5th, I have some difficulty, my lord, on 5th. Can it be then on 7th. Or my friend can check 2nd of May if it is possible for him instead of 1st.
13th of May.
2nd of May is Friday, my lord.
Oh, that's sorry, it's
very
not a
well.
hearing day, that's why.
All right.
Tuesdays and Thursdays will be better for hearing.
All right, Milord. Then 7th is, if it is possible, Milord.
The 7th is again a motion day.
All right, I'm sorry. I'm sorry.
But
Then-
Vijay is projecting that if you can take it on hearing day on any Tuesdays or Thursdays.
So Tuesday,
it will
Milord,
be better because
on 13th of May, Milord, 13th.
Well, 14, my lord, 14. 13, I am occupied, my lord. I have some personal.
Very well,
14th
Milord.
you are
14th.
not there.
14, my lord.
14th is again Tuesday, Wednesday.
Wednesday, yes, my lord.
Wednesday again the
15 May, my lord. 15 May again, my lord.
15th May.
Yes.
15th is a Thursday.
Thursday.
Mr. Viswas?
Yes, Milord.
Any
No.
Tuesdays or Thursdays?
So 15th is okay with me. Milord. 15th is okay. 15th is all right, Milord. Since my friend has problem on 1st, 15th is okay, Milord.
15th is okay.
Yes.
Mr. R. Viswas, learned counsel for the, you are for the applicant.
I'm for the applicant and
R.
respondent
Viswas,
number.
counsel for the applicant.
Yes.
Submit that this, the hearing of the matter will consume some time. So, Mr. D. Pichal and counsel for the opposite party. Public writ petition or the petitioner is present. Next paragraph. As okay, present your names.
Lordship, I'm assisting him on.
Awesome.
Yeah.
Ms. T. Mahmood and then
Correspondent number 3, my lord.
government advocate for respondent 3 and
3.
In IA, they have not been made as a party, my lord.
I not party, my
I
lord.
am
No,
yes, I am passing the first order. Are present. Next paragraph accordingly. The learned counsel for all sides have consented. The matter be listed on 15/5/2025. Stop list accordingly. In the repetition.
In the repetition, my lord, I pray, my lord, the state may be directed, my lord, because our case is violation of section 11 of LARA Act, my lord. Non-compliance of section 11, my lord. No newspaper publication, no, my lord, public notice in the affected area, no Gram Sabha meeting, my lord. This is our case, my lord. Now, state has to file their affidavit, my lord.
Yeah,
My lord,
keep
state
some
may
more
be
time.
given, my lord.
Okay. In the petition, Mr. Pichai is for petitioner. Ms. Mango is the government advocate. He's for on behalf of Mr. Kato, DSGI. For respondent number.
Main case, my lord.
Union of India is respondent number.
Respondent number 3, my lord. Deputy Commissioner.
3.
Yes, my lord. Correct.
No, respondent number 4. In the
Respondent number 4, 5.
I'm sorry, looking at the wrong list. Just a minute. Respondent number 4. 4, 5, and 6. Who's appearing for 7? Mr. Viswas, you are appearing for 7.
Yes, Milord. The writ petition. Yes.
In the writ petition, respondent number 7, Mr. R. Viswas. Next paragraph. The learned counsel of the petitioner submitted that owing to the nature of grievance raised in this petition, the affidavit in opposition by the state respondents would be very necessary. Next, accordingly, the Deputy Commissioner of the Land Acquisition Authority, within bracket respondent number 3, is directed to ensure that the affidavit in opposition on behalf of the state is filed within 13/5/2025, copies thereof to all the appearing parties, so that the matter can be effectively taken up on 15 5/2025. Next paragraph, list on 15/5/2025.
Malad, may I pray, Malad? If not, Malad, let them bring the record, Malad. The records will substantiate everything, Malad. Because if they cannot file affidavit.
In the event the affidavit by respondent 3 cannot be filed, only the said authority shall ensure that the records of the land acquisition
Of Malini
proceedings,
area.
including compliances of various provisions of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act of 2013 have been complied with. Okay. Mr. Biswas, how is my esteemed senior brother?
Yes, Milord. Sir is good, Milord. He's doing good. He's at Guwahati. He's doing good. Thank you, Milord.
Obliged.
Obliged.
May Your Lordship. Your Lordship will file this IA praying for implementation of this society as a party respondent in with petition 167/2024.
You want to implead
Yes, Your Lordship.
as respondent number?
Respondent number 9.
Respondent number 9. Okay. Any objection? Third, next,
C. Bansal.
done counsel for the petitioner. The applicant. Also have applicants S applicants. Ivango and government advocate appearing for respondent numbers 1, 2, and 3. And you are appearing for 4, 5, 6, 7, 8. Mr. E. Pang, the counsel for respondent numbers 4 to 8. Next paragraph. By filing this interlocutory application, the applicant seeks to implead the EMUI Community Land Preservation Society as respondent number 9. Next paragraph, it is submitted that the proposed respondent number 9 is unregistered society. However, without any authority, the said society has taken a decision to reserve only 20% of the total compensation for the female community of the society, which includes widows, daughters or big sisters. Next paragraph. The implement of these said party as respondent number 9, having not been objected to, stands allowed. Interlocutory application stands disposed of. In the main application will say, what's been so? Next paragraph. By another pass today in the connected interlocutory application, implement of so-and-so as respondent number 9 is allowed, has been allowed. Accordingly, the petitioner shall provide a freshly typed out copy of the cost title to the Deputy Registrar within the judicial just to enable, so as to incorporate the same in the writ petition. Next paragraph. Subject to the effective implementing of the newly implemented respond number 9, issue notice on respond number 9, returnable in 4 weeks. Most of the petition shall take steps within 2 days for issues of notice of the newly implemented respond number 9 by the postal AD. Next paragraph. Learned counsel for the petitioners is that liberty to collect the postal receipt number from the registry and submit postal track report prior to the exit of the system. Next paragraph. In view of this order issuance of issuing notice on the newly implemented respondent, the registries the registry shall not place the matter on 23/4/2025 as directed by order dated 2/4/2025. Next paragraph. In terms of para 10 of the order dated 2/4/2025, the learned government advocate shall produce the order, if any, passed by the deputy commissioner, Dimang Valley district, Anini, on the representation submitted by the petitioner. Next paragraph. List after 4 weeks and a date to be fixed by the registry. Also, rise other matters will be adjourned. What is this matter? Connected matter. Here, what orders to be passed? Yes, what orders to be passed here? Something also is represented on the prayer made by and counsel for the petitioner. List after 4 weeks along with WPC 167 AP of 2024.